Hello to my friends. How are you? Hello, welcome to a daytime edition, a day drinking edition of Lolo's Lounge. You are, oops, oh, I should be holding my phallic microphone so that you can actually hear me. Hello, hello. I hope I'm not too loud. Let me make sure. Because, I listened back to the audio of other things and I'm quite loud. And I think you all have been very kind in not telling me how loud I really am. But I just want you to know that I sense that I'm quite loud. I apologize. I'm going to try to be more gentle. Hello, J Rance and Oomph and Pepper and Mindy, TGIF, girl. And it didn't start out so great because, frankly, I thought this was at 11:30 my time, and I think I double, triple, quadruple checked, and it didn't work. Hi, butterflies. How are you? Yeah, right. You never thought I was too loud? Wow. When I listened to it the other day, I was like, oh my God. How did they not run screaming from the keyboard? Okay. And I can't find my phone. I'm sitting on it. Yeah, it's up my butt. Okay. I don't think that is. It's from Oomph is asking about the song that I played at the beginning. It's from a music like a, music licensing website. Volume controls. Yeah, that's true. Maybe I was trying to make it too loud. So I tortured myself. Anyway, neither here nor there. Okay, so we're waiting for this little thing to happen. Little thing. Come on, Judge. Judgy, come on. What's going on? Okay, people, we're not working on Southern time, okay? You can't just start like whenever you want. Oh, actually, he doesn't start till 10. So yeah, actually I'm early. I'm sorry. I'm sorry, Judge. I didn't mean to accuse you of that. I apologize. Anyway. Maybe it just sounds familiar by now. Maybe that's true. Maybe it's like I'm looking for and I'm always looking for like oh, in fact, I forgot to gargle this morning. Do you know, J-Rance, let me tell you how excited I am for ghost stories. Let me tell you. I love ghost stories so much. And the fact, if anyone is willing to come up and tell a ghost story, you don't have to show your face. I would be forever grateful because I just love people's ghost stories or like close encounters and all that shit. I love that stuff. So I am very excited for that. Mm. But and what I was gonna say is that let's see, what was I gonna say? Oh, you know what I noticed? Like my voice,
I mean, this is going to sound stupid. It was like, I was today years old when I learned that. I gargled the other day with like mouthwash, this mouthy washy kind of stuff, but it's like not alcohol-y or anything like that. It's pretty gentle. And it was I thought my voice was a little clearer. I don't know. Ah, J Rance, I love you. I love it. I think most people hate to hear their voices. Yeah, that might be it, butterflies. And when it's amplified, I think that's even worse. Yeah. Yeah, for sure, Z's. For sure, Z's. Anyway, I'm hoping the cats will join us today. I don't know, they're really pretty well camped out on my bed, but I don't know, they might come out. They might make an appearance. Anyway, I hope everyone has coffee. I have coffee. I have my coffee. Hold on. I hope the bottom of it isn't dirty. I feel like I set it down on like breadcrumbs this morning. Anyway, all right. So when's this what's this clown doing? What's this clown doing? Oh, hi Paul. Welcome from Facebook. That's so cool. I love it. Thank you so much for stopping in. We're going to be watching what's happening in Georgia. So actually, that's a great reminder. Thank you, Paul, for reminding me. I should go ahead and you know what? I didn't even like say hello to everyone, and like everybody's saying da, 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 copy cup salute. Oh, and I don't do vocal exercises. I need to do vocal exercises. That's really what happens. Yeah, tomorrow we're going to do ghost stories. It's at 6:15 p.m. Pacific time, 9:15 p.m. Eastern, everything in between and outside of that, and it is on this channel and on the Facebook and on the Twitter, and on Democracy Dino too. It's my little backup. But yeah, welcome, Paul. Nice to see you. Nice to see ya. Come on in. Oh, you watched Harriet Hagman? I can't. I can't. Oops. DIY Pedialyte and coffee. Oh, okay. All right. I see how it is. That sounds good. Hey, Elle, how are you? Got your coffee? You see that? Good to see you. Good to see you. Everybody's here. Doesn't that cancel each other? I don't think so. I don't think is coffee like okay, well, this is it, Max. Those are the kinds of experiences that I just love hearing. So I think that's wonderful. Do 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 do. Caught you on Let's Play the other night, sounding reasonable. Separate vessels, yeah. Separate vessels, yeah. And I mean, is coffee dehydrating? I mean, it very well could be, and I would be like, oh, I'm not surprised by that. But I just don't know that. Okay, it's 10:03. It's 10:03 in the morning. Do 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 do. Do 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 do. Ah, bitch.
PowerPoint, if I could be allowed to share my screen.
That's your brain.
Which computer is logged in for that we need to make? Sure. Which device needs to be
Here we go,
at the
kids.
control?
Rocking and rolling. Can you hear everything all right? Woo, cool, Paul. Come on over. Coffee is a diuretic. Oh, yeah, so I guess it is dehydrating. Oh, duh. That makes so much sense.
Have you requested the hosting?
I think so.
Judge, whose device is it?
This would be Mr. Nolowitz.
Good.
Judge, I don't see him logged in Zoom.
It says C, it's Canolo, it's CANULE.
Okay, you're a co-host.
Thank you so much.
Second, Your Honor.
There's also an in the courtroom version of this going on. What's it on though? Hold on. Let me see what it's on.
All right.
I can't see which one it's on. Start giving voters water again. Yeah, right? Coffee wakes you up and gets things moving, if you know what I mean. Oh, we talk about that a lot. I actually made a resolution this year, Elle, to not talk about pooping so much. But I feel like it's the most insulting
Is
thing
that
I
appearing
can
on
do
everybody's
when
screen?
someone in the Republican Party steps away from
Well, are
something.
you
I like to
sure?
say, oh, they're
Thought it
pooping.
was.
Because I feel like that's
Hold on one
humiliating
second.
and easy. That's all I got. That's why I do it. And that's why I do what I do, people. That's why I do what I do. 6
Share
o'clock in the
screen.
morning.
Yeah, like you're.
Oh, thank
Okay,
you.
let
Okay.
me see what's going on here.
All right. There we go.
Up.
I think it's fine.
There's something.
All right. Okay to proceed, Your Honor?
Okay, I'm gonna make it bigger. Hey, Paul! Yay! You're on day 3.
Give that a shot.
Your Honor.
Okay.
And again, I know that this argument has already been raised before Your Honor at the October hearing. And in reading the October hearing, one of the things that kind of came to mind is, and I know that this seems like it's fairly obvious, but the scope of RICO does not apply to the allegations in the indictment. And I want to start off with something that I think is fairly fundamental, but I think it kind of got lost at the last hearing. And that is that 1614-2 is a law. It is the law of this state. It was passed by both houses of the General Assembly. It was signed into law by the governor, and it is the law of this state. It is not a resolution. It is not a guideline. It is not a suggestion. It is something that the state has to deal with. And in particular, what the state has to deal with is the fact that 1614-2 scope limitation that is contained in subparagraph B cannot be ignored. Justice Peterson in the Harrison versus McAfee case explicitly said that unlike captions, codified preambles are part of the act and are appropriate to be read in pari materia with the rest of the act. And I cite numerous cases on this slide where the Court of Appeals and the Supreme Court have repeatedly said that when you enact something in a preamble or in a statement of intent, that has to be given meaning, and it has to be read with the rest of the statute. The courts have also said, and these are just cases from 2021 to 2023, and I think there's about 25 of them from the Supreme Court and the Court of Appeals. They say that they will not read out of a statute language that the General Assembly has decided to put in there. They are not going to ignore language that the General Assembly has put in there as mere surplusage. So there is going to have to be, the preambles mean something. It is the law, and we are going to have to deal with the language that is in there. Well, when we look at the law and we look at what's in 1614-2, and I'm going to go through several canons of construction. The first canon of construction is that we start with the plain language of the statute. And when the plain language of the statute presents an answer to the question, we can stop there. Here, what does the plain language of 1614-2b say? It says that it is not the intent of the General Assembly that isolated incidents of misdemeanor conduct or acts of civil disobedience be prosecuted under the chapter. Very, very clear. It is the intent of the General Assembly, however, that the chapter shall apply to an interrelated pattern of criminal activity motivated by or the effect of which is pecuniary gain or economic or physical threat or injury, period. At the October hearing, the state didn't deal with and explain what the words pecuniary gain, economic or physical threat or injury mean, and how those are imported to the rest of the statute. It did not deal with the plain language of the statute that it doesn't apply to acts of civil disobedience. And it has to. We have to deal with that language. And here, the General Assembly has expressly said that it is not going to apply, the RICO Act doesn't apply at all to acts of civil disobedience. And we have, in our prior briefing with regard to the First Amendment, we have shown and gone through in detail in the indictment every single allegation, every single thing that the state is saying was done wrong are all statements, political statements that are made around the 2022 presidential election and the vote counting thereof. All of those fall within the category of civil disobedience if that is read appropriately. More importantly,
Where do you find that definition of
Thank
civil
you so much for
disobedience? It's
coming
not
over.
in the
I
RICO
didn't recognize you on
statute
Facebook.
itself,
It's so
no,
stupid.
it's not in the RICO statute. I
You
think
take
that
one
it's,
thing
how
about
should we
your
define that?
username,
I think it
and
should
I
be
will not know
defined
who you are.
as
I will not
a
connect
political
you. There will be no
statement that is
connection. So
in
welcome over here.
opposition
And so proud of you and so happy for
to
you and just
some
wishing you
stated
every
position of the government.
strength.
And here you have a stated position of the
definitely
government that,
given a lot
Joe
of
Biden
love
won the
here for
election,
what you're
that
going
the
through.
vote counting was correct, all of those things. And the people that are indicted here, and the state expressly says it in their introduction, we are
Before you
going
know
after
it,
them
it is
because
like
they disagree.
18 years
That's what they
has gone
say.
by since I stopped drinking.
And so I think that civil
Crazy.
disobedience can be read
Crazy.
for that purpose. Moreover, when you look at what does the statute apply to, the statute only applies to economic, fiscal, or bodily harm. That's what it says. It's
So
the
what do we
plain-
do with the last sentence? That's the one
What's the last sentence?
liberally construed, and the
Okay.
focus is on the operative provisions.
I was going to get to that, but I'll get to it
And
right now.
I think that we wouldn't even be having this conversation but for that last
All right,
sentence.
this is an easy one. Hold on one second. Hold on one second. I apologize. Gotta get to my right slide. Okay, here it is. All right. The state, I kind of feel like it's the Princess Bride, where I don't think that the words that they're using mean what they think they mean. Penal statutes in Georgia, and RICO is in part a penal statute, are always strictly construed against the state. That is the rule at common law, and it is the rule in case law right now. It is strictly construed against the state and liberally applied against the accused. And I've got a couple case sites there. Now, your question, Judge, OCGA 1614-2B says, this chapter shall be liberally construed to affect the remedial purposes embodied in its operative provision. Okay. There are two components of the Georgia RICO Act. There is a criminal component to it, and there is a civil component to it. What does remedial purposes aim at? Remedial purposes, and I took remedies in college and law school, is aimed at a civil aspect of the case. And Georgia courts applying this statute have said that the remedial purposes of the Georgia RICO Act, and this is in the case that I have cited here, the tabletop case, is to provide compensation to private persons injured or aggrieved by reason of any RICO violation. The remedial purposes of the statute apply to the civil part of the statute. It is also well established in Georgia law since at least, 1921, that the remedial purposes of a statute relate only to civil remedies, and that the liberal construction direction in 1614-2B applies only to the civil remedies.
Really?
So as to the
So
civil
criminal-
components,
Whatevs.
the purpose
That's
being
what it
to
says.
compensate
Whatevs. Weird.
persons harmed under
Unprofessional,
RICO,
one might say.
liberally apply. When it is a criminal, as it is here, sanction, penal sanctions, you go to strictly construed. That's what the case law says. And in fact, in the case that we have cited here, the Shearman case, it says the same statute, and that's my bracket, like RICO, may partake of each of these separate elements to such an extent as will render it penal in one part and remedial in the other. And I didn't, my presentation's already clogged up with a lot of words. It's fairly
I've already
busy.
gotten you off track,
Oh.
but let me keep doing
But-
that. Just to
Yeah.
keep you on your toes here. So have you ever seen
Oh,
a
man.
case
It's
applying
hard.
RICO where they've made this distinction between civil and criminal?
It's right here, tabletop. And the other thing that I will say is, and that's the plain reading. And I don't go into all of the other cases. There are cases in 2023, I think I just cited one in here, that talk about the application and the definitions of remedial and penal. There are two different things. Remedial is civil, penal is criminal. And if we dig into it, and if Your Honor wants a very long brief with a ton of case citations, I can do it. But that is what it means. And the other thing that I will say is, even if remedial purposes were to apply here, remedial purposes don't mean that you ignore the plain language of the statute. It doesn't mean that just because if you had a remedial purpose, even for the purposes of civil liability, that you would go beyond the plain language of the statute, which says that this applies to financial harm, economic harm, or physical injury. And I think physical can either be bodily injury or injury to property, probably. But that is it.
So
And if you look, Your
overturning
Honor,
democracy
at
and
what,
stopping the
that
people
is
transfer powers,
explicitly what the
perfectly
General
fine.
Assembly says, and I think we can stop and end
Seems like an oversight.
with the plain language of the statute. But what we can also see is that the RICO limitations are relatively unique.
I know.
So when
I
you look at
remember
the
that.
federal
No,
RICO
I'm still
statutes,
over emotional.
they don't have those same
But yeah, I
limitations
do. It's
that
definitely
Georgia
part of
puts
it.
in there. And we've done some research, and I think that really no other states do. North Carolina comes the closest. And in North Carolina, their
What happened with me
statute,
with
General
drinking?
Statute 75D2C, provides for, it is actually more like our old statute
Eating. That happened with
pre-1997.
me with eating.
But the North Carolina courts, interpreting that scope limitation, have said that the
That
plain
was-
language of the
oh,
statute,
man,
coupled
all
with
these,
legislative
the journeys
intent,
are so difficult
clearly
and different.
indicates that the scope of RICO is limited to cases where pecuniary gain is derived from organized
And we
unlawful
do
activity
so much
prohibited
to
under the
ourselves.
statute. So a
and
North
talking to
Carolina
ourselves and
statute
judging
dealing with
ourselves.
the same type of statute that we have here has imposed those types of limitations to limit the scope of RICO. And if the plain language wasn't enough, we look at what else did
Overwhelmed
the
by
General
life.
Assembly do with RICO. I went through every
Right.
single RICO activity.
It's one
that's
of
listed.
the defense lawyers,
And
he's
every
basically
single
saying, "This is
racketeering
not RICO."
activity that's in
So that's what he's arguing
1614
right now. This is not
35A
RICO.
has to
is
deal with
not Your
either
Beautiful
economic or
Life.
fiscal harm, fiscal being money, obviously, physical harm, or both. And that slide shows where
Yeah.
every single one of those predicate acts are dealing with that. What does that tell you? That tells you that the General Assembly really meant what it said in the preamble, and that it's going to apply
And he's
to
arguing
these
that
types
the
of
last
things. So,
sentence of
when
that,
we're
which
reading the
is
rest of the
key
statute,
sentence, is that
we're saying, okay, yeah, that makes sense. That makes
this
sense.
only
The
applies
General
to
Assembly
civil
has said it in
trials,
the
not criminal.
introduction, and then they've proved it out in the racketeering activities
there.
that they've put there, that those are the primary
These are not
directions of those
construed acts, I
racketeering
think, is what he
activities.
said. I
So
don't
when the
really
state comes
understand that,
back and
but-
says, even if we accept that, one, it doesn't have to be explicitly alleged. You can just bring this up at a directed verdict 6 months later. Or two, we're going to be able to show that in the facts of this case.
I don't think that that's right. We are here on a demur, and in a demur, the state has to state in its indictment exactly what are all the elements, what are the facts here, and that the statute applies. And they haven't been able to do this. I also ran a search in the indictment. What do I not see anywhere in the indictment? There is not one allegation of harm to a body or to property. Not one. There is not one.
that's
If you
his
type in
claim.
the word money, if you type in the word
Yes,
fiscal,
please.
if you
lock
type
them
in the
all
word
up.
economic, it's not in there. And it's not in there because the state's entire
I like The Wire. Good show.
indictment is explicitly premised. Again, go back to their introduction, go back to their definitions of enterprise. It is explicitly premised upon their disagreement with the political speech of these people and the political activities that they undertook,
No.
none of which allege any type of economic or physical harm. At the last
No,
hearing
they just
in
want to
October,
stop the peaceful transfer of
the
power.
state stood up and said, well, maybe
They're
Donald
just
Trump got
acting
money from
in-
being a president. Oh, maybe
attack the
Ruby
Constitution.
Freeman was physically threatened. And my response to that is when we look at the case law, indictments don't get helped by argument or briefing. Indictments stand or fall on what is alleged in the indictment.
And
And the
evidence.
things that were
You forgot
argued
evidence.
at that last hearing,
Sir,
and
They're not in
forgot-
there. But
you
why
forgot
is
evidence.
this? What's your authority that says this is an essential element that has to be
you
alleged?
forgot evidence.
I don't
sir.
think that it's an essential element,
This
but
is
just
Wendy's
like
director.
statutes of limitation, jurisdiction, other types of things, the limitations of the statute are on its face in there. And the state is going to have to say in its indictment for RICO to apply that this is economic, fiscal, or bodily injury. It's got to plead that. And it pled nowhere in there. And the state is simply saying, listen, I want you, judge, I want the courts to just don't believe your lying eyes, cover up what it says in the statute, don't look at what we've specifically pled in the indictment, and maybe coulda, shoulda, woulda down the road, we can prove something. That's not what their burden is in an indictment. Their burden is to state all of the material facts that show the complaint, is state all of the elements. And if they can't show that this act applies, and they haven't shown that this act applies, then it is due to be dismissed. And I think that this is important because not only are there do the plain language and everything else that I've just told you support that argument,
Hey, close your
but
other
you
window,
then get
sir.
to look at the
I
statutory
expect the
history.
paper clip to come up
Georgia
anytime
courts
now.
have repeatedly said that we are going to look
Whatever
at
his name is.
statutory history. Statutory history is not legislative
What's
history.
that paper clip's name?
Statutory
that
history
paper
is
clip's
when
name?
we look at the changes in the statute. And when we look at the changes in the statute, we see that the General Assembly has made a considered choice to do something. And what do we
Oh,
know
why
that
is it
happened in
so- yeah,
1997?
good.
In 1997, there was a case, that Savage case, that looked like it was competing with a couple of other courts of appeals cases. And the General Assembly came in and said, listen, we want to both
Listen. And
expand
that's exactly what they
and
said. It was
constrict
really weird.
what
It was
RICO
quite awkward.
is looking at. We are going to expand it
It looks
by
like you're trying to
adding
bamboozle
economic
me.
or physical threat. That's going to be some additional words that we're going to put in there.
Can I help
So
you,
they expand the
bamboozle?
scope to that. But then in order to get it through, just like
Clippy,
any
right.
legislative
Clippy.
process, you got to get a lot of people to agree.
I expect Clippy to
They
jump on
said,
at
we
any
want to
moment.
make sure
say,
RICO
"I
doesn't
object."
go too far. And so we're going to
I object.
exclude
This is not
civil
in presentation
disobedience.
mode.
Had the General Assembly wanted to come in and said, listen,
Why the fuck
if
can't
you
anybody
have
do presentation mode? What the fuck?
I don't think they could do it
What's the
constitutionally,
point?
but if they came in and said, listen, if you've got political speech, that falls under RICO.
What's
If
the
you've
point of
got
having a fucking
some other
presentation mode if
argument,
you're not going to use
the
it?
violation of Title 21, the election
Clippy.
code, that falls under RICO. What
2024.
did the General Assembly do? It didn't do either of those
check
things
out The Wire.
because
It's
it
a good
didn't
one.
mean
It's
it.
kind of intense.
And here, you're
I
not
wouldn't
even
suggest
dealing with a
binging it. I
statute
binged Breaking
where
Bad. I
you've got
totally did
this,
not. I
this,
do not
and
suggest.
then
I felt like
and
I
then a
was
catch-all phrase, or
a
including
real
but not limited to.
significant
This is
drug
just
addict
clear on its face,
watching
and it
that.
says it's these three things.
And I
That's
didn't even
it.
take drugs.
And we know that the General Assembly in 1997 went through again. This is why I harp on the fact that this is
It's
the
this
law.
canon of I thought I
Is the
read that
General
initially
Assembly
as
felt it
canon
was
of
necessary to
constitutional
go in,
duh.
both chambers, go through the process, go through committee hearings, get the governor to sign it,
Constitutional
to
duh.
make it a law of this state that this is what RICO is limited to, and the state
Oh my
doesn't
God,
even
sorry.
do that here. Moreover,
I'm
when we're
quiet
looking
now.
at these things,
We
if the
need to
plain language
we
and
need
the
to follow
statutory
this in
history are
some
not
way.
enough, we apply the canon of constitutional doubt. And the canon of constitutional doubt will say, and I don't want to take up I see you looking at the clock. I don't want to take up Ms. Clark Palmer's time, but it says that if possible, that we can read the statute in a way that it's unconstitutional, then we really ought to read it a different way. I'm not going to go through all our First Amendment arguments, but clearly there is a problem here that if you read the statute in the way that the state wants, you will render it unconstitutional. And under the canons of constitutional doubt, it ought to be read the way that I'm saying. We've already gone through the strict construction and the limitations. We also look at legislative history. Georgia courts don't always look at this. Sometimes they do, sometimes they don't. We've cited the Gable case, and it talks about what Mike Hobbs had to say, what Senator Clay had to say, what two other people in the General Assembly had to say. And I'm pretty sure I know what Mike Bowers would say. And the only thing that's contrary to that is a meeting at a barbecue restaurant. If you take a look at what the legislative history is, then the legislative history is going to say that RICO only applies to what I'm saying. So you look at then the plain language, the doctrine of constitutional doubt, the statutory history, the application of strict construction to penal statutes, and then the available legislative history. All five of those things are in our benefit. And because all five of those things are in our benefit, then the RICO statute needs to be read in the manner in which I have suggested. And again, the only thing that the state has said, and I've read very carefully the October hearing, is, well,
right? That's
just
a
ignore
weird
it.
flex.
And you can't ignore it.
It's kind of weird.
And Your Honor, because I'm running over, I'm going to stop,
You're
and
wrong.
I may get up and respond to Mr. Floyd if you'll allow me, but I'm going to allow Ms. Clark Palmer to present her issues.
What? Doesn't the
You wanna
judge
go now?
decide
You
when
wanna
he's going
respond
to
Do you mind?
and all that?
I don't have a strong preference.
Okay, if it's acceptable to council, Your Honor, I just
Okay.
soon respond to Mr. Nullis so that we don't
Yeah.
Sure.
Can we keep it clean?
mush everything together, as it
All
were.
right. Floor yours, Mr. Floyd.
Thank you, Your Honor.
Yeah, it's called efficiency.
Thank you.
Lolo, could you please turn up my volume? Okay. I can actually, because I turned it down. Hold on.
I don't need it.
There we go. I'm up a little bit now. I think that's better, right? I can also speak up. That's something I can
Okay,
do.
Your Honor, 1614-2,
see,
the
I'm really
provision that
conscious about
launched
how loud my
thousands
voice
of
is.
MERS. The state does not and has never said ignore 1614-2 like it doesn't exist. That's just not true. Okay. 1614-2 exists. The question is, what, if anything, does it do in the context of this case? And the effort here is to turn it into a pleading requirement. That's the whole name of the game. It's not a pleading requirement. The Georgia courts have held over and over again it doesn't create a pleading requirement. Those rulings are binding. Cotton Inc., Shearson, Roe. Those are decisions of the Court of Appeals and of the Supreme Court. And they say you do not have to plead in accordance with this. You don't have to plead affirmatively that organized crime is involved. You don't have to plead affirmatively pecuniary gain, economic or physical threat or injury, etc. The corollary to that is you don't have to plead the negative either, which is it's not civil disobedience, etc. That's where we sit right now. Okay, that's the law. We're not starting on a blank slate here,
Oh, God.
right?
I'll
And
do some strikes.
my friend, Mr. Nulowitz,
Thanks, Paul.
he's emphasized certain things, but certain things didn't
Can you make me sound like
really
an
get
alien?
mentioned along the way. The United States Supreme Court,
Probably
part
easier to hear
of
than
the argument
podcast.
is that you have to interpret it as he would have it to save the constitutionality of the statute. Okay? No, you don't. The United States Supreme Court looked at that question in
Supreme
Now
Court
versus
said,
Scheidler and said, no, there is no requirement of an economic harm or injury. That's not needed to quote unquote save the statute, right? Nor is there anything about the application of this statute in this case in a First Amendment circumstance that is required to quote unquote save the statute. let me stick to the economic or pecuniary gain or economic harm, etc. First of all, it's not there's no indication that that's a proof burden on the state. But if it were a proof burden, it is not an allegation burden. And much of the game of demurs, as Your Honor has seen, is always let's turn the probata into the allegata. If it's something the state would have to prove at trial, then it must be alleged. The law is absolutely to the contrary. That is not the case. We do not have to plead all our evidence. We don't have to plead in anticipation of affirmative defenses. And these are affirmative defenses. They're not pleading requirements. No Georgia case says these are pleading
His hand
requirements.
is distracting.
Right? The General Assembly hasn't even said they're affirmative defenses. And the General Assembly certainly knows how to do that. There is statute provision after provision after provision in the criminal code where the General Assembly says this is an affirmative defense. They did not do that here. They did not take 1614.4 and say, state, you must prove economic or physical harm or injury, etc. You must prove not civil disobedience. That's not in there.
So then what is the ultimate effect of that sentence of expressing the intent of the assembly? Is it just a suggestion, kind of a hope?
They are generally characterized as precatory words in statutory analysis, yes. And they may provide, in a close question, some guidance to Your Honor. I mean, that this is what we were thinking. This is why we did what we did. But it's utterly illusory to think that this covers all the circumstances of RICO. And this is both the blessing and the curse of provisions like this. There is a somewhat similar provision in the Organized Crime Control Act of 1970. RICO is Title IX, if I recall correctly, of that provision. And a great deal of ink has been spilled going through, it's often referred to as ACCA, the preamble to ACCA, and the same arguments, the siblings of these arguments. You must prove an organized crime nexus. Rejected.
I mean, I'm sure this argument is quite intelligent.
You must prove a racketeering injury because that's what Congress wanted. Rejected. Right? You must prove, et cetera, et cetera. I mean, the history of the United States Supreme Court decisions on RICO is defendants coming in and pointing to legislative history or the preamble and saying, so here's a thing that also has to be in here.
And really,
because otherwise it quote unquote wouldn't make sense. That's what Congress intended. And the Supreme Court has said no. And they've always said no on the basis that we look at the operative provision. It's not there. You know, I mean, when federal RICO was passed, there was endless discussion of organized crime and it's invading the United States economy, et cetera, et cetera. Okay. And when defendants said, you've got to plead this state, you've got to prove it. Civil plaintiffs, you have to prove it. The court said no, because it's not in the definition of the offense.
Right? And so the last sentence of the
but I guess they go through this.
What counsel was saying is that
this is part of the point.
There's this division between criminal and civil.
Plural noun.
Yes, no, there's not. And the case
Where's the recommendation request in treaty?
Okay? And Georgia has never done that.
In legal instruments.
And the problem is what he's saying is, as a consequence of his interpretation,
no effective gift or right,
it's completely untenable because it means 1614.4 A, B, and C mean one thing in a civil case and another thing in a criminal case. That makes no sense.
Why is that untenable?
Because you've got to figure out what each word means, right?
So he points to remedial. I guess they could have. They didn't have to include the word remedial. They could have just said effectuate the purposes.
Yes, but it's operative provisions. 1614.4 is an operative provision. The application of those operative provisions in both civil and criminal cases do have remedial impacts. For example, under Georgia RICO, there's a provision that expressly says a defendant who's convicted of a RICO violation is stopped from denying the facts of that violation in a subsequent forfeiture proceeding. I mean, these are integrated. It does flow through. And so a criminal conviction does have impact on remedial provisions down the road. And that's expressly in the statute. General Assembly knew exactly how to do that when they wanted to. But in contrast to the statements of intent, in looking at this, in the first sentence, the General Assembly declares its intent. Second sentence, its intent, not in its intent. Third sentence, is its intent. Last sentence, shall be construed. Not, it's our intent, our general sense, our suggestion, our recommendation, or please think about this, courts and
Boy,
prosecutors.
those words,
It is
they really
shall.
mean things, don't they?
Mandatory language. Only time
That's
shall
really
is used
interesting.
in the provision. And that is the language
It's the
that
first
you
time I
looked at
understood what
in
he
your
was
earlier
saying.
ruling of October 17th. That is the language that the Court of Appeals has looked at as well. Pecuniary gain. The argument was made to you that after an exhaustive look through the statute, that every violation defined as racketeering activity either causes economic, physical, or bodily harm. That is manifestly not the case.
What? How are you
Perjury.
on my phone?
False statements, tampering with evidence, obstruction, forgery, destruction of evidence are all violations. None of them necessarily cause economic or physical harm. None of them, all of them
I know. Thank
are
God.
defined as acts of racketeering activity. Those are just the examples
No.
I could come up with off the top
No,
of
they're
my
talking
head.
about
There's
toe
probably
fungus.
many more than twice that. It is simply
Is that
not
it? Is that the
an
boom?
accurate
Oh, damn it.
characterization of the statute. That is not how this statute was built.
Quiet.
It was built long before 1997 when this was done. And there is no such structure. That's what they tried in Now versus Scheidler. And that actually goes back to a Second Circuit case called Ivich and another one called Bagarich, both of which imposed an economic motive requirement. Those were rejected by the United States Supreme Court. Why? They said, we're not having a seance here about legislative intent. We're looking at the operative provisions and it's not in there. Okay. And if this was a limitation, if this was a requirement, absolute requirement, as Mr. Nullis would have it, it would be in 1614-4A, and it is not. The presumption is here that somehow the state has to allege in the indictment exactly every economic impact, exactly every harm, exactly every bit of anxiety. Nothing says that. Nothing says that. Has the state alleged a circumstance where it could not do so? Has it precluded itself from doing that? Absolutely not. Nowhere do we say there's no economic harm, pecuniary injury, etc. Nowhere do we say this is civil disobedience and exercise of First Amendment. No, that's a characterization of the evidence that they say they will put forth at trial. That is not a pleading contest. We are not in the 17th century here. Economic harm. We allege data was stolen. We allege equipment was intruded into. That's economic harm. All right, that data has value. That data is defined by the relevant statute as property. Economic gain. Well, the name of the game, as I pointed out when we had earlier argument, was to make Mr. Trump president, even though he lost the election. That carries with it a lot of things. A very large salary, benefits, retirement benefits that are very substantial, the most prestigious residence in the world, and the most prestigious transportation in the world. In anyone's mind, that is economic gain.
And is the trio of cases around Sevchek in the 90s, is that really the last time this ever appeared in a Georgia case?
Well, Cotton Inc. is a little more recent. Cotton Inc. is in the 2000s.
It's been 20-something years since anyone's tried this?
It's been a long time. They've pretty much given up on it. Perhaps the motivation here is more powerful.
That doesn't mean that you don't. Come on now.
No, this has been essentially
Mar-a-Lago
regarded as a
isn't that- this
discredited
is
argument.
weird, stinks.
Um,
I think he meant the White House. Hello.
the
I can't.
let me turn to civil
Oh, God.
disobedience for a
Please
moment.
don't fuck this up, Georgia. I
Um,
love you guys, but
Mr. Cheeley
please don't
tries
fuck
to
this up.
recharacterize
Please.
things like his false
I need
statements
you to nail it.
regarding vote counting as an act of civil
I need
disobedience.
you to Nancy
Right.
Pelosi this bitch.
First, again, as we've said before,
just
1614.2 doesn't modify the essential
Nancy
elements
Pelosi
of a
it
violation. It
and
doesn't
make
create
it
them.
happen.
But second, there is no basis
Pull it
to
together.
conclude that his conduct for this
Eileen,
court to determine
welcome.
as a
I'm so
matter
glad
of
you're
law
here.
that
Cool.
his conduct was civil
Welcome,
disobedience.
welcome.
And you've been offered none.
Hmm.
It just said it. It's just Dipsy Dixie.
I live in a huge
Okay,
town. and I don't
so
have a huge
that term, as
town.
you pointed out, Your Honor, is not
Didn't
defined
realize.
by the statute. It's not
So
defined by
Cindy,
any other
but
provision of
big town.
RICO or any other Georgia statute. Pretty much leaves us looking to common parlance. Where does that take us? Well, the New Oxford American Dictionary calls it the refusal to comply with certain laws or to pay taxes and fines as a peaceful form of political protest, right? Other dictionaries use essentially the same definition. It is a fundamental concept of civil disobedience that the person engaging in the disobedient conduct acknowledge what they are doing, acknowledge they are violating the law. That's actually the point. And that they accept punishment for it. I looked at the Encyclopedia Britannica article on this. The civil disobedient, finding legitimate avenues of change blocked or non-existent, feels obligated by a higher extra-legal principle to break some specific law. Is because acts associated with civil disobedience are considered crimes, however, and known by actor and public alike to be punishable, that such acts serve as a protest. By submitting to punishment, the civil disobedient hopes to set a moral example that will provoke the majority or government into effecting meaningful political, social, economic change. Cheeley did no such thing. We don't allege he did it. He can't introduce facts controverting our allegations in connection with demur because it becomes a speaking demur and the court has to deny it. But Cheeley, one thing we know, Cheeley denies violating any law. Cheeley is not a civil disobedient. There's no reasonable interpretation of the term civil disobedience that could include soliciting public officers to violate their oaths, not the oath of the disobedient, somebody else, asking somebody else to commit a crime, making a false statement or writing, committing perjury. Okay, those are acts that Cheeley is charged with. Under no definition is that civil disobedience. And simply getting up and saying, I have some questions about an election, that's not civil disobedience. Okay, and he says he invokes the First Amendment again, but that's not what they're charged with. That's the problem. They're trying, they don't get to modify our indictment. They don't get to edit it, rewrite it, etc. They can go to trial and present facts if it's a legitimate defense, but that's it. Solicitation of somebody to violate their oath is not civil disobedience. Lying by making a false statement is not civil disobedience. Perjury is not civil disobedience. These things are deceptive. These things are immoral. It is not calling forth a higher moral principle. It is being sneaky and dishonest. As a co-conspirator, Cheeley is also responsible for the acts of his co-conspirators, all of them. Impersonating a public officer, forgery, filing false documents, influencing witnesses, computer theft, computer trespass, computer invasion of privacy, conspiracy to defraud the state, to deceive the state, acts involving theft. Under no reasonable interpretation is any of that civil disobedience. It doesn't become so simply because the defense would like to don a particular mantle. Most importantly, none of these defendants admit any of the crimes they committed.
Yes, but
which
are
puts
they
them directly
actively
at odds
locking
with the
everyone in the
fundamental premise
courtroom?
of
No,
civil
they're not.
disobedience.
No, they're not. That's why you come here. So you can see me mock the entire. I mock everyone involved. Just kidding. I won't. I love everybody. Where was I?
As I said before,
Don't get back to
this,
your
it's
non-presentation
interesting.
presentation.
This has not been asserted as
It
an
is.
affirmative
Internet has been a
defense.
saving grace for a lot of
And
people,
I think
especially since
that's quite
COVID.
conscious because the defense know then they have to go to trial
And a weapon.
and have the burden of coming forward with evidence on that.
Um,
Instead, they're trying to turn it into a
What did
sort
I
of
do?
super affirmative defense by
Oh, no, I
elevating
think I
it to a
deleted
point that
someone's
lets
message and I
you, in
didn't
essence,
mean to
push
do
an
it.
override
Oh,
on the indictment.
I
But
deleted
again,
the
and I
message and
mentioned this
didn't mean to
briefly
do it.
at the beginning, when the General Assembly wants
I
to
hit the
create an
wrong
affirmative
button.
defense, they know exactly how to do it. And I'll give you just a few examples. Article 3 of Title 16
Oh,
consists
fuck, man,
entirely
I'm
of
so
affirmative
sorry.
defenses. 16810 creates the claim of right
Screen
as an
text.
affirmative defense to theft offenses.
Work.
16620 and
Yes,
21
exactly.
create affirmative defenses to
That
bigamy.
could
And
be
every one of these
mind
says
fucking
it shall
people.
be an affirmative
That's a-
defense. False or fraudulent identification.
Did I do anything?
1694.
Oh, can you say? Oh,
Um,
good.
1611
Can you say
127.
anything of?
Carrying a weapon in an
I don't fit
unauthorized
in.
location.
Yes,
1612
that, Paul.
141. Abortion.
I feel that.
1613
You fit in here.
32.4. Transaction in
I
controlled
hope I didn't-
substances or marijuana within 1,000 feet of school property. In every one of those instances, the General Assembly thought under some limited circumstances, there should be an out.
I deleted.
And they said what
a
they meant,
comment you
and they
made,
put
like,
it in the
early on,
statute.
and I didn't
And they
even
said,
know
you
I
know,
did
defendant,
it
if you
'cause
can
I just,
establish
like,
this,
I must have
you
touched my
are
phone in
not
such a
guilty.
way as to.
They
affect
did
that.
not do that here.
And I was
Um,
worried that I did something. Yeah. Anyway. I know. Gosh,
I'm happy to answer any questions.
I've got that
I
on my
think I
mind
had
too.
one other point.
I'm having
The tabletop case
conversations
that was
about
cited as being a
location.
RICO case, it's not.
Another double-edged sword.
Um,
Exactly. God, there's really no perfect. There's no ideal. And you can be lonely in the largest place,
That's,
right?
you know, when we've talked about
But
this
there is
before,
more chance of finding people
there
that
are
will,
statutes out
really
there.
get you and understand you.
There's one in the Gang Act,
I
provision in the Gang Act, which is very
It
similar
was
to
the-
RICO.
it
General
was the-
Assembly didn't
it was-
include it here.
Wait, which one was it?
Basically says the
It
court
was-
can examine whether the charge is
That was a
consistent with
volume
legislative
one.
purpose. New York has
even know how I
a
did
judicial
it.
override provision
Deleted
in
the
its
comment,
Organized
that's
Crime
all. It
Control
didn't
Act
do anything.
that specifically allows
Never-
a judge to
deleted the
dismiss a
comment. I don't
case
know.
if they believe the prosecution is not consistent with the purpose of the statute.
Yeah. Yeah.
The General Assembly
So,
did not
That's
do
why
that.
we just have to hold on to each other.
They
Hold
did
on.
not, in essence,
Don't hurt each other.
cross the wires
Hold on to each other.
between
Much as
the
possible.
branches. These devices
Oh my God.
exist,
That's too many. I gotta
but they are not
get a
here.
tissue.
They are not in this circumstance. And the defendants
Sorry.
have not given you
My
a
eye is
way
watering really badly, so let me get
to
a tissue and I'll
logically
BRB.
apply the provisions as they would interpret them, which are manifestly incorrect. Let me be correct. To this case, what they want you to do is just make a sweeping statement that the defendants call certain conduct civil disobedience, therefore it is, therefore pleading requirement that's utterly undefined and utterly uncodified wipes out the indictment. That makes no sense. And quote unquote civil disobedience would now suddenly become a defense to almost every RICO case, because almost everybody's going to say, I did it for a higher moral purpose. Normally that is no defense at all. And the General Assembly knows how to enact an out like that, and they did not do that. And in fact, their final admonition is that this provision shall be liberally interpreted. The argument that is being made is one that's, the two arguments that are being made are ones that are intended not to liberally interpret to achieve remedial purposes, but to gut the statute. No Georgia court has done that. No Georgia court has suggested that that's appropriate. And the decisions that exist interpreting this provision do not leave that leeway. There is simply not room for that approach. They have gone exactly the opposite direction. And they were right in doing so. What they did was entirely consistent with what the United States Supreme Court has done with RICO. The find a requirement game, that is, find a requirement that's not in the operative provisions, apply it, and use that to dismiss a case, is something the U.S. Supreme Court has rejected over and over and over again. And it's important because it's a game that has no end once it begins. And it, in essence, amounts to rewriting the statute as the General Assembly enacted it. Because the guts of this statute are 1614-4. That's what tells us what a violation is and what a violation isn't. They want to change it. They want to add to it. They want to really add words to that provision. And not just words that would create a proof requirement, but words that create a pleading requirement.
Oh, thank you, Eileen.
And so we
Sorry
now
about
get into
that.
an endless game where the
Sucks.
state would have to
Thanks for
anticipate every
Spending
possible
the time that you were able
defense
to spend.
and plead in anticipation of it.
Wait, here
And
we go.
according to the defendants, plead every fact
Oh.
it has in anticipation of that defense. There is no Georgia law that does that. And
That's
now
true.
is
There's
not
lots
the
of
time to start.
benefits to living in
Thank
a
you.
small place.
Thank you, Mr. Floyd.
I dig that, but I also understand.
I'm going to beg you for some more time from Mr. Clark Palmer.
Sure.
Just very quickly, the only thing that we are arguing here is in the four corners of the indictment. It doesn't state a RICO claim. It's not an affirmative defense. It's not anything else. We are within the four corners of that indictment, and do they or do they not? I've heard a lot of references to the United States Supreme Court. The federal RICO statute doesn't look like the Georgia RICO statute. The Georgia RICO statute is unique, and the General Assembly here has explicitly said what it is limited to. At no point in time in Mr. Floyd's remarks did I hear what does it mean to limit it to economic, fiscal, or bodily harm,
Mm.
because they don't have an answer. The other thing that he said,
Drugs have really
there
fucked
seems
up
to be
this
some
country.
type of issue. Well, this hasn't come up in 20 years. No, it has not. Why? Because as they admitted in the last time that we were up here, this is a unique case. Prosecutors understand what RICO means. And they have taken the RICO statute, they have morphed it and twisted it and cajoled it into something that the General Assembly expressly said it does not apply to. And why haven't we seen this come up in 20 years? Because nobody else has dared to do it.
What is
With
that?
regard to the three cases that
What is
Mr.
that?
Floyd
Nursery
referenced,
rhyme?
Cotton versus Fieldman, he says that there's no requirement in the statute to allege a
Patty
nexus
cake.
between organized
That's it.
crime
Man,
and
I
the
was gonna
economy
say
is of
maybe
no
it's fucking
consequence.
crazy.
That's what Cotton
Patty
said.
cake,
What do
patty
we
cake.
know from
Here
Ms.
comes
Clark
ma'am.
Palmer's Kimbrough case?
Bake
Yeah,
me
you
a
do.
cake as
The
fast as you can.
Georgia
Bake me a
Supreme Court
case
has expressly
as
said
fast
that
as
you
you
do have
can.
to do these things.
Roll
Cotton,
it
a civil
and roll it
case,
and work it with a
Rehal, a
bee.
civil case. And when you look at them in
And
those
throw it
cases,
in the
all of
oven
them
for
are
baby
alleging
me.
economic harm, which was the
I used to think about
statute
how
at
to
the time. The
change
statute was
those
changed
words.
even after
But yeah.
Cotton. Cotton was dealing with the
Mighty
1996 statute. The
Morphin
General
Rico
Assembly changed
Rangers.
it in
Oh my God, Max. Hold on.
1997.
That's really funny.
And so at no point in
I don't have
time
enough hands.
do those cases
I want
don't
to come back
apply
as
here.
somebody with
And
more
when
hands.
I'm listening
Mighty
to
Morphin
the
Rico
argument by
Rangers.
the state, they seem to think RICO's got this talismanic magic that it covers everything, and that when they
Or
say
you
it, they can
can't
circle
have
kick a
things in your
defendant.
yard
No,
now. That's
you
terrible.
have specific limitations in the statute
I
as
think
to
we
what
need
it
to take a
applies to.
collective
You've got
deep breath.
enterprise. You've got all of these different things. You got to have a listed predicate act, and it's got to be economic, fiscal, or physical harm. That's what the
If
General
you
Assembly said, and they've
made
said it over and over again.
Dumpy
And Justice Peterson said it,
Dumpy
and the cases that I
McDumperson
cite to you
president,
say it, that you've got to give that some effect, and the state has failed
that
to
would
do that at all
hurt
here. With
a
regard
lot
to
of
the
people's
other numerous
economic
references
status.
to other courts, our courts have said that it does have meaning. Our
Well,
statute
put
is
it.
unique in the
Oh,
nation,
Thank
And
you.
with regard
Let's
to
roll
how
it
the
on out.
Supreme
Yeah.
Court has taken
Had it and roll it.
issues,
Yes.
and
Thank
whether
you.
or not it has
Thank you, Heidi.
applied
I know. I was going to drive you
RICO
crazy.
to
I'm not
issues
gonna lie.
of protected constitutional First Amendment activity. I got a whole slide with
It's
lots
been
of
a minute.
different cases, but it starts off with Alexander
many
versus
things
the
in my
United
hand.
States, 509
I like
US
this
544,
microphone.
555, 1993. The RICO statute does not criminalize constitutionally protected speech.
This is not a free
And it
speech
can't.
case.
And what do the words, we get off on, you've got to,
This
it's
is
some type of
not
throw
a
in
case
civil disobedience where I've got to be
centering on
willing to go to
freedom
jail.
of speech rights.
What the common definition is
Period.
under Merriam-Webster, refusal to obey government
Full
demands or
stop.
commands, to disagree with the
As the
government,
kids would say.
forcing concessions of the government.
As the
When the
corporate
statute
kids
was
would say.
applied and you look at the law review articles and other things that surround it at the time of the statute, they're trying to make sure that abortion protesters, environmental protesters, people that are getting up and saying, listen, I disagree with you, that they're not going to jail.
Oh,
And in the
this is so
20
much more
years,
than that.
25 years since this statute has been
This
passed,
is not
that has not been applied in one case, one time, except for here. And why hasn't it? Because the statute doesn't
These
apply.
lawyers should be
And I've given you
ashamed of
5
themselves.
reasons. Plain language,
There's a point at which
statutory
everyone does
construction,
deserve great
statutory history,
representation. I'm fully in
strict
support of that.
construction. We didn't
And I'm fully
hear
in support of
any
like defenders,
differentiation. And you've got the cases and you've got the discussions about penal
and I just
versus
wonder,
liberal.
in this
And on
case-
that, again, even liberally applied. You've
What
got to give
is
effect
the-
to the plain language
Yeah,
in the
it's not
statute, which
about
they're
the
just not
protest.
conceding.
It's not
can
about
happen.
the
There's
protest.
no
it's about the
explanation.
actions taken.
And with regard to the indictment, you
It's
have
about
to
the
say, if
actions
the
taken.
act is going to apply, you've got to say in the indictment itself, I'm not looking forward to trial. I'm not looking
What
forward
you
to
said,
proof.
gosh, I hope this guy's
Somewhere
wrong.
in here,
But
in its
let me
4
read what
corners,
Val's saying.
you've got to say that it
January
applies to those
12th,
things, and they
Houthi
don't.
militants mistakenly targeted.
Thank you, Your Honor.
Oh, really? Oh, interesting.
Your Honor, may I
Oh,
correct
boy.
one statement?
Sure.
Yeah, well, you asked me a question. I realized I gave you an incorrect answer.
Okay.
And it was whether this argument of economic or pecuniary harm as a requirement has come up in the last 20 years. When
Yeah,
I
I
answered
wonder-
quickly and I'd forgotten, it was argued by the defense in the APS case. It was rejected. The argument was not raised on appeal, but that's less than 10 years ago.
But the order you're going to have on that is just at the trial level?
I mean, the only ruling was at the trial level.
Okay.
But
Had I been representing the teachers, I would have.
We're going to push forward.
Reuters just now
Understood.
posted. Haven't
All right, Ms.
seen
Bowman, how
video
much time do you
yet.
need?
Okay, thanks.
Good afternoon, Your Honor.
No,
I did
don't
hear the court's
know.
instructions to
That's
say
the
basically
problem.
tell me something I haven't heard yet in the brief, so I will endeavor to do that. I do want to preface my argument by explaining to the court the reason we handled the argument in the way we did by kind of starting with the substantive counts and working our way back up to RICO was to show you the problems that we see with the underlying conduct that the state has alleged in this case. And the reason why we have all these weird crimes like conspiracy to commit solicitation of violation of an oath of office and things that we don't think fit into the substantive crimes is because this indictment is seeking to either criminalize constitutionally protected activity, or the counts don't provide us enough information to prepare our defense, like the solicitation of the violation of oath of office for the legislators, or perhaps the counts charge activity that might be a crime, but it's not a racketeering activity. Perhaps maybe it's something that would be found in the election code, a crime that would be
no, I
found
don't
in the
agree with
election
this.
code.
I don't know. I'm not
But
a
it's
lawyer,
not
but I don't
a
agree with
pattern
what
of
she's saying.
racketeering activity or a racketeering act as defined by our RICO statute. And so because the state is trying to shoehorn this conduct that doesn't fit into a RICO prosecution, you've got to dismiss this indictment. We think it demonstrates
Because
the
they
fundamental
can't let
flaw
such happen.
with their prosecution. So
I can't
our
stand any
arguments
of 'em.
about the
Isn't Trevion
enterprise and that we
Clarice-
think
but
the
she was
indictment
required to
doesn't
appear today.
have limits on who could be
She must
part
be at the
of
defense
the
witness.
enterprise and doesn't appropriately define the enterprise. So I'm going to kind of truncate that part of my argument and skip to
stand any
the
of
next
them.
part of my
I
argument, which
can't
is
wait till
about the
people like Doug
nexus
Frank
between
and
the
David
activity in the
Clement
indictment
and Joe Altman
and the enterprise,
and
because it's
Ivan Raiklin and
interrelated.
Mike Flynn
And
and Roger
that's the part that I
Stone
know
and
you
Alex
mentioned,
Jones and
or the court
Boris
mentioned in its order
Epstein
back in
and
October denying
Steve
the
Bannon,
demur for the other defendants,
that other guy.
that the indictment did
I can't wait
allege
till
a
all of them go
sufficient
away.
nexus and that it did appropriately define the
Their
enterprise.
arguments
But
are actually
the order
correct.
didn't provide a lot of detail or facts
I don't think
that the
they're
court had
correct.
relied on. And so
I
I'm
could be wrong.
going to
but-
present some other arguments and facts that I would ask the court to look at and reconsider.
Okay.
So yes, in our view, the failure to appropriately provide detail between the alleged criminal activity and the enterprise is a Kimbrough problem. It's not a general demur problem. We're not saying that you haven't alleged a crime, because count one does use the words that are in the RICO statute. We're saying you haven't given us sufficient.
So Kimbrough's nothing at all, right? That's the quote. Nothing at all was in Kimbrough.
Yeah. So what
We've got
Kimbrough
something
was,
here.
right? Kimbrough was count one is RICO, and then counts 2 through 50 or whatever are just substantive crimes themselves. They were all VGCSA crimes for the different people.
I don't know what that
And the
means.
Kimbrough Supreme Court opinion listed, here are some ways we can imagine these people could be associated with the enterprise. Maybe they're employees, maybe they're patients, maybe they're doctors, but the indictment doesn't tell us which one of those it is. So look at this indictment with an eye towards my client, Mr. Smith. Same problem. He's mentioned 19 times in the indictment. Okay. Every single time he's mentioned,
Here's the
it's in
case
what
they're
I've called
referring
kind of
to.
like the caption of either the count or the substantive act, right? It said we're
Here's the
alleging
case
that
she's
this
referring to,
person committed this
Kimbrough.
crime on this date. Except for one, there is one act where it says he and Mr. Schaefer encouraged other people to sign a document. Okay. There's no information in the indictment about what Mr. Smith's connection to the enterprise is. Is he a lawyer for the campaign? Did he have some phone call or some email where he's
I think
communicating
the
with
evidence is
somebody
gonna
else
come out at trial.
who's
my
alleged to be
dear.
part of the enterprise? That's what we don't know. Okay. And this is
Mhm.
why we think Boyle is so helpful to our argument. And I know the state says, yeah, but in Boyle, the defense lost. Okay. That's because, the defense was asking for a fairly specific jury instruction. But there is still some very helpful language from the majority opinion in Boyle, right? The Supreme Court did hold that the ongoing organization must have some sort of framework, whether formal or informal. And they said, we agree with petitioner that an association in fact enterprise must have a structure, that there are 3 structural features: purpose,
Okay.
relationships among those associated with the enterprise,
Purpose. Okay.
and longevity sufficient to permit the associates to pursue the enterprise's purpose. And very
Bingo.
helpfully, I think, the opinion says it's easy to envision a situation where people might engage in a pattern of racketeering activity, but not establish the existence of a conspiracy.
Oh,
If
have you
several
met Jim
individuals
Keysbro?
independently
He's got a lot
and
to say about
without
that.
coordination engage in a pattern of crimes like bribery or extortion,
Mm.
proof of these patterns would not be enough to show that the individuals were members of an enterprise. So I was trying to think of another analogy, and what came to mind was thinking about the protests around what we all call Cop City, right? There have been some people who have been arrested and charged with a RICO enterprise in that case. There's also been other people who have protested.
Mhm.
They have the same goal
This
as the
isn't
people who want to
protesting. I don't
stop
understand
Cop
why
City.
these people think this is
They've done it
considered
the same
protesting, because
way.
it's simply not.
They've gone to
You don't take
demonstrations.
actions in furtherance
Perhaps
of
they've
a,
even committed crimes.
of
Perhaps
a
they've
lie.
committed criminal trespass. Perhaps they've done those things at the same time as other people
Oh, sweetie.
who are alleged to
Sweetie.
be in this
Oh.
RICO conspiracy. That doesn't mean that everybody who shows up
This is the
to
A game.
protest and to commit a criminal trespass
This is the A game.
to get to their goal of stopping that training center to be built, is in a RICO conspiracy. So look at Mr. Smith in this indictment. The first time he comes up is in Act 23. But there's nowhere in the indictment where it explains, what
Wheel.
is his relationship
Says that a water
to those
lets pass
who are associated
an
with the
issue in
enterprise.
every US
At
state.
most, he is alleged to have committed certain acts,
a
either all by
water-
himself or at the same
What?
time
I don't understand
as
that.
other people.
Maybe-
But there's no allegation of
Mhm.
how his acts are connected to the
I don't know
enterprise.
what that
That
means.
that
I'm sorry.
nexus is missing.
It's a me
And
problem.
that's why
I'm
count
sorry.
one cannot stand in this case.
Oh, you.
So-
well, you didn't do
Let me
it.
go back.
You didn't do it.
Um,
Oh, I'm sorry. Thank you for trying. Thank you for coming today. Appreciate that.
Winter.
Oh, winter
now,
weather alert. Okay,
another
wait.
argument that I
Newsweek
know we've heard from the state
says that a
about
winter alert has been issued in every U.S. state.
conspiracy and
I
some of the
understand.
conduct
I'm sorry.
that is alleged in this
Thank
case
you. Now I
is
get it.
that this is
Really?
a RICO conspiracy.
Crazy.
And they've said a couple things. Number one, we don't have to prove
Crazy.
that, or allege, I'm sorry, we don't have to allege that
I think
two
they will be able
racketeering
to
acts
prove the links
were committed because it's a
between
conspiracy.
Cheese bro has
Okay.
got a lot
But
to
you do still have to give
say.
us
Boris
enough
Epstein? Oh, we haven't
information
even heard
to
from
prepare our
him yet,
defense
darlings.
under a special demurrer
Woo-hoo! And let me
analysis,
tell
right?
you, Boris is not
And
going to prison.
we know
for
that when we have compound crimes
anybody.
like
He's a
conspiracy,
real
and especially
lawyer.
like
Well,
RICO
kind of.
conspiracy,
No, it's okay.
that the state
Siegfried, I
does
got
have
it.
to descend into the particulars
Oh,
and
links
allege
will
how
not,
the
show up. But if you just
criminal
put, like,
objectives or
the
goals
core
of
the
that
link,
compound crime were
then people
going to
can
be
copy it.
reached. So
the core part.
one case
Yes.
that
Now
the
we get
court
it.
can
Thank you
look
so
at
much,
for the
Siegfried. That's
proposition
crazy.
that a compound
Right here.
crime has
I think
to
it's windy
allege
still, but it was windy this morning.
at least the elements of the underlying or predicate offense is
Yeah.
a Howard
What about
versus the
it?
state,
What about
which
it?
is 252
I need a-
Georgia Appeals
Here, really.
487
I was
from
painting and I had
2001. That was
ink
a
on my fingers
vehicular
and it just
homicide case.
stained it.
Okay, so
Like
the
paint
defendant
or
was
paint,
complaining,
like
well, you've charged me
stained.
with vehicular homicide, and you've alleged that
Bizarre.
the underlying traffic offense was reckless driving, but you did not allege one of the elements of reckless driving. Now, the defendant didn't succeed in Howard versus the state because the indictment alleged vehicular homicide with
Mhm.
reckless driving being
Okay.
the traffic offense, but then it had a separate count. And in that separate count, in the reckless driving
And how is this
count,
helping
it
you?
did sufficiently allege the elements and the details. So what does this tell us? What does
Yes, what
Howard
does
tell
this
us?
tell
It
us?
does tell us that an indictment has to either allege the essential elements of the predicate offense or charge the predicate offense completely in the separate account,
Okay.
or somehow in the indictment, put the defendant on notice
Mhm.
of the predicate offenses by the facts
Mhm.
alleged in the
Okay.
indictment compound crime was committed.
Hmm. Oh, the storm at last.
Okay, so either put it in the top
Finally.
level, the predicate offense,
Finally.
charge the predicate offense. I'm sorry, put it in the top level, put it in the compound
The
crime,
storm unites us.
put it in a totally
The
separate
storm and
predicate
sweaters.
offense
Sweater
charge,
weather.
or
It's
else
sweater weather.
allege somewhere
Oh
in the
no,
indictment
Paul, be careful.
how they
Oh my
are
gosh. Make sure
connected,
your
how
like
the
water is like, a little
predicate
turned on, I
offense
guess.
is
Hi,
connected to the
Jason.
compound
How
crime
are
above.
you? Good to see
Another
you.
case that
my
stands for the
friend. Good
proposition
to see you.
that
Yeah, we're just
RICO is a
we're just
special
new boot
type of
goofing.
compound
We're
offense,
goofing. We're new
not
boot
simply
goofing
a
over
more
here.
serious grade of forgery,
Listening to
robbery,
piss poor arguments
homicide,
and
or
desperate attempts
other predicate
to
acts is the Cotman case, which is
salvage
the
all
APS
that
case.
is left of our
In that case, Judge
reputations and
Dillard
our
said this is a compound
stature
crime.
in the
Okay, so put
community.
those two cases together, and that tells us, yes, it's a
He's one of
RICO
the defense
conspiracy,
lawyers.
but you still have to
He's
give us
kinda terrible.
sufficient detail of how
Paul says, "Hi,
the
Dempsey.
conspiracies,
Must be well,
objectives were going to
hello.
be
Oh
achieved.
no,
When did
we
we,
do have supplies? Thank God.
what is our relationship to the
Thank God.
conspiracy?
I really hope
What
it
is
goes
Mr.
for
Smith and the
everyone
other
to
defendants?
do
What is the
really cold
relationship
temperatures
to the
and or
conspiracy?
whatever the
It's got to be something more
Please
than
be safe.
just,
Please be safe.
you all had the same goal.
Make sure you've got one of those radios that
Maybe
you can
you were
listen to
committing
anything,
the
right?
same acts
You're in
on
a
certain
trailer,
days.
water is flowing. There you go.
And maybe you
That's
have the
like
same objectives.
Southeast
You've
Michigan.
got to
Be
have that
safe.
nexus.
Get off
And
the
that's what we
road.
don't have here.
Okay. Gosh, really? That's so, it can be so
It does, the
painful.
indictment does allege that we functioned as a continuing unit for a common purpose, but never goes on to explain
Oh, it will.
how anybody
Oh.
functioned as
Oh,
a
baby.
continuing unit,
Oh,
particularly
just wait.
Mr. Smith.
Wait for
Um,
Dr. Eastman, and then followed by Kenny Chesbro.
It does also in different
Don't forget
places
about
in the
Sidney
indictment.
Powell, you know
says,
that time to fun.
Things like that the criminal conspiracy
You
had the goal to
think your
unlawfully change
client's
the outcome
gonna
of the
get
election
away
in
with
favor of Mr. Trump.
it.
Okay, that's not a
You
RICO conspiracy.
try to
The conspiracy has to be
argue,
you had an agreement that somebody was going to commit
two
2 acts of racketeering activity, not 2 crimes.
Don't
So that's not
put
sufficient
food
to allege a RICO
racketeering,
conspiracy in this case.
even when
It
it's
does have a bare bones,
fair.
1 sentence allegation
Boy,
that the
said
conspiracy's
he's
common
coming up
plan and purpose
behind and
was to
singing
commit
a song
2 or more
about
acts of
the sea.
racketeering activity
I just
in
made that
Fulton
up.
County and elsewhere.
Yeah.
But nowhere does it
I'm
give
kind of good at
sufficient
that.
detail
Do I remember
as
them?
to the
No,
connection
never, ever.
for Mr. Smith or defendants to the
It's only
conspiracy's
getting rain here in my hotel.
common
Oh,
plan.
Jesus criminy. That's terrible, Mindy.
That's
That
what's
is-
missing. The enterprise that's alleged in the indictment, I know
Mhm.
that the state says
Oh.
our argument is like, the sky is falling, and that
Maybe
it includes
luck for
anybody
everyone.
and everybody. That's
Yeah,
our
but-
argument is not that broad, but our argument is that the state hasn't sufficiently
and pray for
cabined
good plowing.
the enterprise to fit within a
Little
RICO
shoveling.
conspiracy, because the indictment alleges that people who were part of the enterprise,
He has cute dimples, though.
which
I
is
like
an
his dimples. I like
association,
her hair. I like the
in
suit.
fact,
I like the
enterprise
suit color.
reaches far beyond just
Like
the
a-
19 people named
Like
in
a
the
deep
indictment.
sienna.
It includes
it. It's a great
unidentified
color.
co-conspirators,
So I'm gonna get
people
all-
known and unknown,
And she's very
people in
eloquent.
Georgia but outside
She's
Fulton
wrong.
County,
That's all.
and people across the country. That's
So,
too
I have
broad
no problem other than the fact
to
that she's 100%
sustain or to pass a
I'm
special demur
I'm sorry. I'm having a real
analysis in this
problem with
case.
people that
We know that there were
defend
millions of people
this
who did and perhaps
particular
still
storyline.
want or still believe
I
that
have a
President
problem with
Trump
that.
won in
I don't know how you do
2022.
that. I don't know how I
There
would
were
be able to do
thousands,
that. I mean, I think
maybe
it
even
takes a
hundreds
lawyer
of
to be able
thousands
to
of
do
people
that.
who took various
Freaking
actions to
nonsense.
try
The sky
and
is
challenge
falling.
and
The sky is
overturn
falling,
the
and they
results
just
of the
all
election.
happen to
There were
decide to go
thousands
to
of
the
people
same
who
office at
engaged
the
in
same
unlawful
time and take the
activity
same
to
equipment.
accomplish that goal. Criminal trespass,
That's all.
disorderly conduct, even more violent actions. Even those people who had the same goal and perhaps
Is
took
racketeering the
steps
same as
that
duty
constituted
or
crimes to
predicate
reach that
crime?
goal,
Is that like
still
memory,
doesn't mean
What
that
is
they
a
are
predicate
part of a
crime?
criminal RICO enterprise.
or is that just specific crime? They called it precatory. Yeah, she should have Grok there. He would know what to say. I'm assuming it's a he, because it's I don't know. That seems really stupid and gender focused. So, Grok, the entity.
Your Honor, I think I have covered everything that's different or
Okay.
additional to something that you've
Have
already
you
heard
though?
from us
But have you?
in our
But have you
briefs.
though? Did
So
you
I will just
do
sit
that?
down and I would like just perhaps a few minutes, if necessary, to respond to Mr. Floyd.
Is that something that
Thank you, Ms.
you
Palmer.
think you should do? Hey, give me coffee. Give me coffee. Give me coffee. Hey, give me coffee. Yeah. Yeah. Kathy.
Opportunity to
Where have you guys been? Can I just say?
All right.
Oh, they have to pee?
What's the
Oh, damn it.
host's name?
The host's name.
State of Georgia.
Probably should have
State of Georgia. Georgia.
Mr. Derryberry, if we can have the state of
Georgia.
Georgia as a co-host.
No peace I find.
They're a co-host now.
But something sweet song,
Thank you.
please go into presentation mode.
Your Honor, Kimbrough does not control here. I mentioned
Kimbrough is
1614-2B
just not
is
in
the
control here.
provision that launched 1,000
Oh,
demurs.
I get
Kimbrough
it.
is
I'm
the
just
case
kidding.
that
I'm
announced,
totally kidding,
that
Tony.
has
I'm sorry.
launched 1,000 demurs. And
I'm just being silly.
my friends and the defense are very proud of their win in that case. And that's fine. That's all great. But
Everybody
Kimbrough
deserves to feel like a
is not the
winner
universal get out of
sometimes.
jail free card that they would make it. As you pointed out,
Mm.
the court in Kimbrough said actually said one thing. There's a second one that's corollary to it.
Really should get my
The
nails.
first was that indictment said absolutely nothing about any relationship between the
I'll have to deal with.
acts of
Every
racketeering
time
activity
they say Kimbrough,
and
I think of
the
that campy
enterprise.
X-Files.
It gave
Touch on-
3
oh,
examples,
wait.
federal case law, where
I
the
think
allegations
that's what's
were adequate.
triggering me
The
too.
second part is the court said specifically,
That's a good one.
we are not saying we want pages and pages of detail about these relationships. And that's the bookend on this. Okay. And so we're not in a situation again where we get this creep that is the state has to allege every single detail, has to tell the defendant what his own motives were, has to tell the defendant everything we have that he did that we think exposes him to liability. No, that's not it at all. And there is no Georgia case that says that. And so we have 2 things going on here. We have a specific argument primarily regarding the Boyle factors, and then we have more general statements about pleading. I'm going to try to jump to the Boyle aspect of it first, but this is really the last argument Ms. Clark Palmer made. And so that began because the defense clearly recognized they'd overshot the mark in their brief. And so they disclaimed their argument that basically we would, if I recall right, we'd have to start converting football stadiums into prisons to incarcerate all the people who are uncovered by this enterprise. No, that's not true. First of all, there's no such number of people charged. And second of all, this is based on a straw man argument. The enterprise in this case does not consist of thousands, hundreds of thousands, or millions of people. It does not consist of everybody who voted for Donald Trump. It does not consist of everybody who supported Donald Trump or everybody who ever asked a question about about the relevant election in 2020. We don't say that. They don't get to rewrite our indictment for us. Okay, another basic principle of Georgia law. It's just not in there. The fact that an indictment says there are persons involved unknown to the state is completely unremarkable and means nothing in this context. Here's the difference. Act 95 in the indictment. Defendant Trump placed a call to Rusty Bowers, an individual who has spoken out a number of times about what happened, the Speaker of the House of Arizona Representatives, in which the indictment alleges Mr. Trump solicited, requested, and importuned Mr. Bowers to unlawfully appoint presidential electors from Arizona.
Yeah.
Something the indictment says he also did and his Confederates also did in at least half a dozen other states.
White Lion.
In that call, Bowers stated to Trump, I voted for you.
Loved that
I worked
cartoon.
for you. I campaigned for you. I just won't do anything illegal for you. And therein lies the difference. Bowers did not join a conspiracy to unlawfully overturn the
I know.
election.
Boy, they just
And to
they
say that's
couldn't
not a
keep
RICO
Rusty.
conspiracy is ridiculous. Okay. The definition of a
Keep
RICO
your mouth
conspiracy
shut.
is set forth in
Why can't
Cotman
you do
2.
that? I just
And it
don't-
basically says a person who knowingly and willfully joins in I'm going to slightly mischaracterize, it's actually in the PowerPoint I'm going to show in a second, basically an endeavor that contemplates committing 2 or more acts of racketeering activity. Not that they have to commit them, not that the acts have to be committed. We've laid this out in our briefs over and over again, citing the United States Supreme Court's decision in Salinas, which makes it abundantly clear You don't have to commit a violation of the substantive offense to commit the conspiracy offense. That's not how conspiracy
That's
works.
right. That's
Otherwise,
not how it
conspiracy would
works.
accomplish
That's not
nothing.
how any of this
Okay?
works.
It is enough to insist, to provide assistance.
Sorry.
It is not
I'm just trying to
necessary
keep up here.
to commit the substantive violation.
Thank
Therefore,
God for
it
Rusty
follows
Bowers.
it
I
is
mean,
not necessary
really,
to
there
engage in
are
the
some
acts of
people
racketeering
that
activity.
with
So everything you just heard about
with,
not
and
identifying
spoke
acts of
out,
racketeering
'cause I
activity
remember-
falls out in a
I think I heard
conspiracy
Rusty
case
Bowers
because it's
speaking out at that
not
time.
an element. It is relevant
Right.
at trial. And United States versus Elliott makes this point. While the conspiracy requires that there be some contemplation that acts of racketeering activity
Here
will
we
be
go.
committed, they are not
Series
required.
3 or
However,
season
of
3, episode
course,
20.
if the
Jose
defendant
comes from outer
actually
space.
engages in it, or his
Oh, for the
co-conspirators
win.
actually engage in racketeering activity, that is certainly evidence of
Oh,
the
for the
agreement
win. I
and
haven't watched
entirely
that show in
relevant.
so long.
But the fact that it is
Who lives
admissible
in deep
evidence does
darkest
not turn it
Africa?
into a
Who's the
pleading
one who bought
requirement in a
Rock
conspiracy
Hall of
case.
Fame?
Nobody has been charged with
Kimba.
voting for Donald Trump. Nobody has
Oh
been
my God,
charged
you guys
with
are
working
amazing.
on the Donald Trump
Brilliant.
campaign,
Brilliant.
soliciting a vote,
Brilliant.
calling, trying to raise money. None of that. People have been charged because they did something illegal for him or they assisted other people who were doing something illegal for him. The state has identified specific persons in that conspiracy, both the defendants, and has provided the identity of the unindicted co-conspirators.
You don't have
It's
to have
made it
actually
clear that
robbed
the
the bank. You
enterprise's
don't have to be
common purpose
successful in order
was
to
to
be
unlawfully overturn the election results
guilty.
and to do it through a pattern of racketeering activity.
That's kind of what it
The
is.
state identified 161 overt acts in furtherance of that
It's Kimba.
and identified
Now I have to
relationships
go. I'm
between
gonna have to go
those
listen to that
persons, identifying
theme song,
specifically people who
Max.
acted
Thank
together.
you.
These people, according to the indictment, and the
And
indictment
have
is read
advanced
as
years
a
and
whole,
really
and it is read in the light favorable to the state,
Well, you know,
okay, is
redemption is
it
eternal.
shows 2, 3, 4, 5 or more persons acting together.
Redemption is eternal.
They communicated, and we allege that. They
Kimba has a
coordinated,
white
and we
line
allege
and that's
that.
his
They
name.
went to
I
meetings
am gonna
together.
look it up.
They
I'm
traveled
gonna look it up.
together.
I'm gonna do it right
They
now.
talked to
Hold
each
on.
other.
I'm gonna
They
find it.
talked to each other about what they were doing in furtherance of the conspiracy. As Boyle observes, the existence of an association, in fact, is oftentimes more readily proven by what it does rather than by an abstract analysis of its structure. And I think that language is clear here. I'll point out that the indictment, since Boyle has been invoked, could you skip to slide 44, please? And as encouraging as that may be, I can't promise I won't go to some of the earlier
I
ones.
think we're gonna have to move on here shortly, Mr. Floyd.
All
So
right.
I'll give you
I'm
about
gonna have to
3-4 more minutes.
All right, Your Honor, I'm at your pleasure.
wrap it up.
First, Boyle has not been adopted by the Georgia courts, so it's not Georgia law. But second, if it was, and knowing the possibility that it was, clever little fellows that we are, we studied it carefully and we followed it. Okay? And you heard those 3 requirements that it operate for, and I'm doing these in slightly different order than they're actually stated in Boyle, that it operated for a period of time sufficient to permit its members and associates to pursue its objectives. We specifically allege that on page 15. Okay? And 161 overt acts show nearly 2 years of activity that consisted of a frenetic, coordinated, nationwide pursuit.
Thank you, Jane.
those
I'm glad you
That's all over
understand,
you.
or at least appear to
The
understand.
defendants and other members had
Albinism.
connections
What?
and relationships with
Kimba?
one another and with the enterprise.
Why is Kimba
We
white?
show that. Okay?
Well, I mean,
We
just
allege
because
that
there are
expressly,
there
same
white?
page.
I think we've seen white tigers.
It consisted of an ongoing organization whose members and associates
Really?
function as a
Welcome,
common unit
Jane.
for a common
Back.
purpose
Welcome
of
back.
achieving the objectives of the enterprise. Same page,
That
15.
is some Rudyard Kipling
Boyle is
shit.
all
Yeah,
there,
no, it's definitely
laid
is.
out.
It definitely
What
is
they're saying is we
problematic.
didn't plead
Kimba
our
is
evidence in
problematic. I'm
support of it. That's
confident
not
of
the
it.
requirement.
But I do
Also, by the
recall it.
way, as to the
I do recall
longevity
watching
argument,
it as a child.
in Georgia, only 2 acts are necessary to constitute a pattern, Your Honor.
Remember when they
Recognize
used to
that in
show
an
like
earlier
Ricky
ruling
Tikki
looking at the
Tavi every
binding
year,
Georgia
like
Supreme
the
Court case
Rudyard
of Dorsey
Kipling
v. State.
animated
So
show?
establishing a pattern, pardon me, of racketeering activity, were
We
it
didn't have
required,
nearly
and it
enough
is not,
education on what was
is
what
something that happened
growing
very
up.
early on in this, and they continued to pursue it.
I blame Mark Burnett.
The,
No, I don't blame Mark Burnett.
you
I
take
blame
one,
all of
please?
us.
I have a couple of points in
Plenty of
these
blame
early
to go
slides I'd
around.
like to make very quickly, if Your Honor will permit.
That's
And
true.
I'll provide the
And the
court
song
with
is
this
much more inspiring
indictment
than I
with the
remembered it.
PowerPoint. And so that you'll see the sites. That way I
Oh,
won't
my
have to
God, my
go
eyes.
through that.
I must
But
be
when
having
we
like
say
an allergic
sufficient
reaction or something.
information,
It is kind of windy today, so I'll
let's
just go with
look
that.
at what is happening here. First of all, we're not required to
Very
plead the
funny,
evidence.
very funny. Yeah,
That's
we have to
clear. I
cancel
cite
everything, and
Stapleton for that.
I'm actually
It
not
is
being
not
flip. I
necessary
actually
for the
am
state to
okay
spell
with
out in the indictment the evidence
it.
on which it relies for conviction. Noticeably,
I know.
Mr. Smith's argument avoids the actual Georgia RICO cases that talk about the sufficiency of an
Yeah, the
indictment.
Kimba
The main
theme
ones
song
being
is
Grant,
much
which you
more
cited
grand.
in your
Let's hear
October
a little bit of it.
17th argument, and Pasha itself a Georgia RICO conspiracy case. They go through this. The indictment clearly gives Pasha notice of the nature of his involvement, the overt acts attributed to him, and the underlying predicate offenses. That's it. All that's required. Grant, the requisite predicate acts and
Why is
enterprises
Kimba
comprising the
like the
charges against appellants are
self-proclaimed
precisely described and
king of
named in each instance.
all the
No
animals?
greater detail was required to
And
allege the
like,
RICO
does that mean
offense
he's
under
like king
Georgia
of all
law.
the lions?
Those are the controlling
Don't other
cases.
lions probably have something to say about that?
When the argument that
I don't know.
is being made to some extent, and in the PowerPoint, we go through this, the standard under
Oh,
federal
yeah.
law is exactly
Mark
the same
Burnett
for
should
the
be
sufficiency of the
canceled.
pleadings.
Jungle
And
Book
we
has
provide
been
about a half a
canceled.
dozen examples
Rudyard Kipling is
of
canceled. Definitely.
federal
J.K.
cases
Rowling. I mean,
reviewing
there's
the
a lot of people.
sufficiency of
Lots
indictments,
and lots
and
and
they
lots.
don't require any of
Lots of
this.
canceling.
Could you take me to 14, please? And I realize time is coming to an end, and I'll go through this quickly, Your Honor. So the
How
argument
quickly?
you heard is, we
How
don't say
quickly?
anything about the relationship between these defendants. Well, we laid out
Watch
161
me.
overt acts. Some of them are
Watch me
committed
say
by an
something
individual.
now.
That's the only
Doo-doo.
only person acting. An example would be perjury. There's only one person who
Trump ordered
testifies.
to pay $362,000 in attorney's fees to New York Times.
A
after his
voicemail left. There's
That's
only one
hilarious.
person on the phone. All right. But there are quite a few where these
Oh,
individuals
yeah,
act
Hemingway,
together. And when
Mozart.
you look at it,
Most of those
these
dudes,
are
right?
each on the screen, each
them.
examples of
Jungle Book
overt
from
acts where
1967
individuals are
next to its
acting
King Lear
collectively. They're
character.
acting in
Yes,
groups.
Yep.
Trump with Giuliani 5 times.
Yeah, no, it's
Trump with Meadows 3 times. Trump with Eastman
I
4
think it's
times. With Ellis
a far better
and with
world
Powell.
if we acknowledge
What happens?
what
How do those people connect?
perpetuates systemic
Giuliani
racism
connects to
and
Trump,
pain
to
and
Meadows, to Eastman, to Powell, to Ellis,
desensitization
to Chesbrough,
and
to Smith,
dehumanization. So
to Chile.
there's no
I have
problem.
not put all the defendants on
That's a
here
fine use
because
of cancellation.
life is short. But I think these examples are sufficient.
I think people should
Eastman,
be
in
hurt by
turn,
media.
as we
I don't
know,
think,
connects to
that
Trump
should
and
be a goal
Giuliani,
that we're
also
not like,
to Ellis,
unless
also
you're a
Chesbrough,
bad guy and I'm
also to
punching up.
Smith. Smith connects to Giuliani, Eastman, Ellis, Schaefer, Chile. You notice you're seeing many of the same names over and over again. You're seeing groups of
Oops, and
1,
guess
of
what?
2, 3, 4, and 5
Giuliani
people
and
acting
Ellis
together.
and
Those are the
Eastman are
relationships
gonna
that Boyle talks about.
talk.
They keep
talk,
doing
talk,
these things.
talk,
This
talk,
isn't them
talk,
having
talk.
lunch together.
And Ellis is pretty
They're
believable.
not playing fantasy football. These are
I don't
overt
know.
acts in furtherance of this conspiracy.
She who smelt it is
Chile
gonna dealt it.
breaks the bank. He
Chile.
connects
Oh boy,
to at least
you're
10
everyone.
of the defendants in this case. These are all overt
Oh,
acts where they're
dear.
communicating together,
Oh, and that is
where they're acting
threat of
together,
physical
where
harm.
they're moving in
I think they
furtherance
did
of this
threaten
criminal endeavor.
Ruby Freeman, did they
More
not?
than
Am I wrong about
more
that?
than sufficient to
Am I wrong about
satisfy
that?
any requirement of a common
Didn't they
purpose or
create
of a
sufficient
relationship.
fear in her for her
Happy to
life?
answer any questions you have, Your Honor, but
All right, if you could email that to
False
us.
imprisonment or
we
the
will be done.
threat of
Appreciate it.
false
All right,
imprisonment?
last
Isn't
thought, Ms.
that?
Palmer.
I mean, huh? Meow? Meow? Which one? Mozart. I know. I guess. Well, I think. I don't know.
I think that everything Mr. Floyd
can't-
just
I
said
remember the
about what's
movie
on
Amadeus,
page, it's on
now I
page
just don't
15 in the
remember
indictment
particularly
about
what
what
it
they
was.
allege
He
as
was
to the
a
enterprise helps
grab-assing
them
baby.
survive a general demur, but not a special demur. And that's what our
He was a
complaint is. I
grab-assing
agree with
baby ass.
him.
Hi,
They
basket
don't have to
package.
plead their evidence. I agree that they don't
Ruby
have
had to move.
to
Ruby can't.
plead or prove that two
Yeah,
predicate
that
acts
to
were
me.
actually
I'm sorry.
committed, but you
That
got to give us something.
totally fits.
You have got to give
She
us something that
articulated
tells us
articulated it
what is
very
our
well done,
connection and
Paul. Very well
relationship
done.
with one another. And the last slide that he pulled up that said so-and-so connects to so-and-so, I have this memorized as to Mr. Smith, so he's the one I can speak to. What that means is he's in the same place at the same time.
Oh.
And if we were robbing a bank,
Oh.
okay, that would be problematic. Because
Okay.
there aren't millions of people or thousands of people who are out there on the same day at the same time in the same place trying to rob a bank. But
What?
in 2020 and after,
What?
there were thousands of people,
No.
maybe even more than that,
No.
who were in the same place at the
No.
same time, undertaking the same efforts with the same goal vis-a-vis the 2020 election.
Okay.
And that doesn't mean they were in a RICO conspiracy
Really?
together.
It doesn't? Oh.
One point I want to
You know
say
who's
just
gonna
about
say,
Grant, because I know the court
is
did
Kenny
cite to that
Chesbro.
in
Kenny
your
Chesbro's
previous
gonna
order
drop
in
names
October.
like
Grant was a much
hot.
more clear
Because
cut,
they
so to speak,
are.
case. It's
I
the
love
timber
Pete
case,
Brammer.
right? The
And
indictment
sometimes, I don't
alleges
know,
an
sometimes I don't get it, but
association
my
and
daughter
fact,
will
but
watch it
says
sometimes.
in the
Ruby and Shay
indictment
both had to
that it
plead
was
their home
part
for
of the
fear of
criminal
violence.
enterprise
I'm
for the
sorry.
people
I
associated
understand that. I understand
within
that
the
they have been
enterprise to inflate or
their
deflate the
lives will
value
never
of
be the same.
timber. I'm
They
skipping
will never
over
get
some
what they're
words just for
due.
time's sake. Forging
It's gross.
contracts
It's
about
like
the timber. It goes on and on.
recriminalization.
The
It's like
success of the
re-criming
criminal
on
enterprise
people.
depended upon the cooperation of the defendants
Sorry,
to
man.
move the timber product through their various companies until its origin or final destination was hidden from the true owner. Okay, so that's the information we're asking for.
What?
We're asking for the state to tell us give us something about our connection to the enterprise.
Okay.
And it's something
will.
more than we were in the same place at the same time on the same day.
Really? Doing the same thing. You forgot
Stating
that
our
part.
beliefs. And when they say overt acts, again, as to Mr. Smith,
Uh-huh.
every overt act except one,
Okay.
every overt act matches up to a substantive count. It's just you committed a crime in this place on this day.
Okay. But did
It's
he commit
not
the
you made a
same
phone
crime as
call,
the other
you sent a
people?
tweet, you sent an email. It's not anything that would address his relationship and connection with the other people alleged in the enterprise.
What?
Thank you.
I know, it is gross.
All right. Thank you, Ms. Palmer.
It's unacceptable. It's really unacceptable.
So I want to transition over. We had listed out several of the other issues now still pending. I think the thought might be here.
Oboe.
Let's
Oboe. Yeah.
if the folks, we haven't been too boring to the folks on the Zoom call. I think we want to check in with them, see if they're still with us. And I think we would start with
still with you?
the motion to
Okay.
withdraw. And then we can transition over to Mr. Sadow's motion and Mr. Giuliani's motion after maybe a short break for the transition. So with that,
wait, hold on.
see Mr. Cohen's here. Do we have other counsel?
Boop.
All right. So
Boop, boop, boop.
if we could perhaps make some room at the council's table, we'll move over into the motion to withdraw. And you might want to, like I said, check in with as of now, your client to see if she's still with us.
As of now? What does that mean?
And I can
What
see
does as of now mean?
a box, but I don't know if she's.
That's weird. What does as of now mean?
Good afternoon, Judge. This is Steve Greenberg. I just don't have my video on because I know we're not supposed to speak on the Zoom, but I just texted her to turn hers back on.
All right.
Okay.
Thank you, Mr. Greenberg.
Thanks, Mr.
We're dressed to
Greenberg.
shovel
Mr.
here in
Green
Chicago
Jeans.
today.
Thank you, Mr. Green Jeans. We really appreciate that. I'm Stephen Greenberg, and I'm here to represent. Who's he representing? Oh, I'm sorry. You actually were asking a question. I'm so sorry, Margaret. I thought you were making a clever joke, and I didn't really understand that. I spy with my little eyes a vast organization behind these crimes. And do you know who's going to speak on that organization? Well, is going to be Kenny Chesbro, and it's going to be Johnny Eastman.
All right, Miss
and
Cootie,
it's
are you
gonna
with
be
us?
Boris Epstein, and they're going
I
to
think I still see you muted, ma'am.
sing for their lives because no one's going to prison for that guy. Well, maybe
I'm here.
Rudy.
All right, great. Can
Maybe
you hear us all
Rudy.
right?
I can.
Mhm.
Okay, so Mr. Cootie, just a few things I wanted to take up with you. This shouldn't
Indeed.
take more than a minute or two. On December 18th, your current counsel, I think that's Mr. Cohen, Mr. Greenberg, and Mr. Herman, had filed a motion to withdraw from representing you in this case. And in that motion, they said that they have informed you of a few things, including that going forward without counsel can be is usually not a good idea, and encouraged you to obtain new counsel. Did you get a copy of that motion or that notice, or did you have a chance to speak with them about what it would mean when they withdraw?
I haven't spoken to Mr. Cohen at all, but I have received a copy of the notice, and I have spoken to Mr. Greenberg regarding that. Yes.
All right. And we didn't get any kind of an objection to that within, I think it's the 10 days. And so at this point, ma'am, I believe your attorneys would be allowed to withdraw from this case. And so that leaves you without an attorney upon the signing and the filing of that order. So there's a few things I want to go over with you here, and we can kind of get a sense of how we're going to proceed. So obviously, you always have the ability to
judgment
hire another private counsel.
So
You also have the constitutional right to represent yourself,
there's
and
not any
but that's something you have to do diligently.
sympathy.
You can't delay things simply as we wait for you to find alternate counsel. So you also have the right, if you can't afford it, to public representation. And so I guess my first question to you would be, is that something that you're interested in exploring to see whether you qualify for public representation?
No, sir. I will be attempting to retain one of the lawyers that is on this call, and then number two, seek an additional counsel.
Okay, and who would that be? There's someone on the call right now?
Greenberg.
Mr. Greenberg, you're trying to retain him?
Yes,
Okay, I think he's one of the ones who filed the motion to withdraw, though.
correct. And we've had conversations on attempts to move forward. So in this case, I think he understands particular arrangements that will be made. And I do understand it is his decision at the end of the day, but
what in the actual
that
fuck
is
is
my thought.
happening? What are
and
certain
my,
arrangements?
approach on this situation.
What are certain
Okay,
arrangements?
so, yes, sir.
May I explain, because rather than, I don't like talking in circles, and I think I want to make the record clear. So I have known Ms. Cootie for a long time. And when this first came up, even before the indictment, I said I would help her out. And she had the belief that people were going to be able to assist her in meeting what I perceive to be fairly minimal professional obligations, given the scope of the work. And unfortunately, those people did not assist her. So if at some point in the future, she has the ability to have private counsel, I would be willing to assist her. I've gone over the discovery, received all of that. But at this point, given the fact, especially where the prosecutors are saying it's going to be at least a 4-month trial, I just simply can't help her as a friend. And so I think that's what she's referring to.
All right, so you're still pushing forward and would like the court to grant this motion to withdraw, this
don't know all the
unobjected to motion to withdraw,
details
Mr.
of-
Greenberg?
But she
Yes,
did
Your
work
Honor.
for Ye.
All right, so Ms. Cootie,
Oh.
it sounds like that you have a game plan, is that you still want to see if you can get Mr. Greenberg to sign up, but if not, you've got some other options in mind that you're pursuing. And is that accurate?
That's correct.
Okay, the date's March
So,
4th. Okay,
That's
So
just
it's
what I
gonna
wanted
start,
to
bitch.
emphasize,
It's
is
gonna
that I
start.
would urge you to
Period.
continue to seek
Period. Oh
out
wait,
that
maybe
private
that's the other
counsel,
trial. Now I
not to
can't
put this
remember.
on the back burner.
I think it's
And because I have to caution you that simply if it gets to within a trial date, whenever that is, or another hearing date that's very important to you, if a counsel comes into this case the day before, the week before, even a month before, and asks for a continuance, that's probably not going to be granted because, again, you have to show that you've exercised reasonable diligence in obtaining private counsel. Does that make sense?
That makes a lot of sense. Yes.
All right. So the idea is I'm probably going to also be bringing you back for a very similar situation in a month or two to check in to see where you are with obtaining private counsel. All right.
Correct. Thank you.
All right. Do you think there's anything else we need to go over today then?
I think not. Thank you so much.
All right. Thanks for joining us. That'll be all. Ms. Goody, thank you.
Thank you.
Okay. And Mr. Cohen, Mr. Greenberg, I'll have that proposed order signed on the docket. Thank you all.
Thank you, Your Honor.
All right. Did we have counsel for Mr. Giuliani with us as
Hey
well?
Glenn,
Yes, sir.
how are you?
All right. As
New
you're coming
title.
up and get situated, why don't we
Listening
take
in from
5?
the
I'll come back,
shitter,
and
the
then Mr.
Twitter,
Sadow will
Twitter
kick it off
shitter.
with your motion to compel.
Welcome, my friend.
Fine, Your Honor.
All
Good
right.
to
I'll be
see
back
you.
in
I know,
2:45.
popcorn, major popcorn. Okay, they're going to take a break. All right, so what we're going to do is we're going to get ready for it because you know you want it and you know you got it. And I don't have to have that up there. Okay, and then we do this and then we do that. And then we do that and then we do that. Okay, don't screw things up. Okay, thank you. Little hot mic action. It's boring. Okay. So anyway, and then when I was 12, no. Wow, this is a lot. This is a lot. So here's my takeaways so far. That last part with Trevi and Cuddy was very awkward, and I have a feeling we're still going to hear people complain, maybe her, maybe those around her, complain when the trial date is announced and she has not yet, she has dragged her feet. Because I think, here's what I think some of these folks are hoping that Dumpy Trump gets back into office and that he will make it all go away. I know that's what Rudy thinks. So I think maybe she is also of the magical thinking persuasion, like Rudy is. The magical delusion that is anything to do with Rudy Giuliani. Yeah, so I think that. I think that I don't know if John Eastman. I don't know. Am I dreaming that I heard John Eastman is not going to be allowed to flip? Is that something that did I hear that? I don't think I heard that. Oh, hell yeah. Magical thinking. Yeah, it really is magical thinking. It really, really, really fucking is. It's just stupid. He can't, okay, Paul. Paul, do you remember when there was something to do with Michael Cohen being put back in jail when Bill Barr was Attorney General? Granted, that was a federal case, so I totally understand. But what I'm going to tell you right now is that I think there's been a lot of work being done behind the scenes to figure out how to make state crimes go away, even though you are the executive branch. So I have no doubt in my mind that if he were elected, that he would figure out a way to make state crimes go away. Hi, easily distracted. How are you? That's what I think. Wait, what? Wait, what? How could what be? How could what be? Oh my God, what did I say? What value any assertion from Eastman? The only thing Eastman to me would be able to give a value would be who were architects beyond his level of the design, right? Like that's what I think. However, I think that he would still probably go down for, I don't know, because he wasn't really a leader. He wasn't really a leader of anything, but he was a magical thinker. Yeah, when magical thinking meets reality, which certainly happened even in the hearing room where he lost his, or is going to lose his license. So, there's that too. First thing Trump would do is get rid of the justices. Yeah. Like I just think that things would change very drastically under a new regime. But he's a chronic liar. Well, and he's also lazy. Oh, you mean Eastman? Yeah, he is a chronic liar. And so that I'm not saying that he would have, well, and the thing about it is, here's the thing. They already have all of his fucking communications. Okay? They got him in a parking lot at the mall and got his phones from him. So they've already got all his communications. And he is just blusterous and egotistical enough that he didn't encrypt or hide anything. Right? He didn't have the Russians that Rudy had to help encrypt all of his communications. He might have had Boris Epstein though. And Boris Epstein, not saying that because he's Russian. I'm saying it because he's Boris Epstein. And Boris Epstein is committed to committing crimes. Committed to committing crimes. Maybe they'll find an old circa 2000 OLC memo. Yeah. Right, Dempsey. Remember the Fulton City grand jury named Donald Trump and Cleta Mitchell. Oh, God, Jane, thank you so much for reminding us about fucking Cleta Mitchell. There's another one. Okay, so there are people like Ginny Thomas. John Eastman knows all about Ginny Thomas. And I don't put it past Jack Smith to say, you know what? I am going to go for the Thomases. I wouldn't put it past him. I wouldn't put it past him. Rasputin, yeah, for surezies. Not at the Jack in the Box, right? No, you're at the Wendy's. Are you behind, Siegfried? Eastman done. Oh yeah, he's done. Easily, you're so right. John Eastman is done. And the other good thing that could come out of John Eastman's kind of demise is that it would expose the Claremont Institute and that just how much they have been involved in mind fucking America and the world, frankly, that would actually get some play in the mainstream media. I know. I'm naive. I get it. I get it. Yep, she's the architect. Right. So that's what I think Eastman could do. And Boris, I don't know really what Boris. I'm a little confused on what Boris's role. I have to read the indictment again. Just in, Republican-led House Judiciary Committee says it's launched. What? Oh my God. Thank you, Gal. Here's the link. Thank you, Gal. Tamar Hollerman status, her Twitter showing a story reported by Gal just in, Republican-led House Judiciary Committee says it's launched an investigation of Nathan Wade, the special prosecutor in the Fulton Trump case. Are they allowed to interfere in state level cases, the Congress? Are they allowed to do that? I mean, I understand. Hi, Nipple. Nippy. I don't know how to say your name. Nippy? Nippy? I'm so sorry. Jenna Ellis is talking or taking? Oh, yeah. Well, yeah. I don't know. No, I meant that one of the crooks was arrested. Oh, right. Well, Mike Lindell lost his phone at the Hardee's drive-thru. Yeah, that's true. True. Get the money. Okay, there's the other thing. End Citizens United, and let's galvanize together, like reunite the country around getting money out of politics. I know that Gal has said this so much, and I so agree. I think that if we were able to get money out of politics, that would be such a huge start. You know, and that would you could revamp lobbying, right? So that it was truly representing groups that were, didn't have a huge marketing budget to get people's attention, right? I mean, really, yes, I remember. That was so fantastic. And then Doug Frank talks about that was the pillow guy, yeah. Doug Frank talks about coming out of the airport men's room and like I think I had my belt undone still. I was doing my belt and then I walked out of the men's room and then oh my god, there was FBI agents right there and they took my phone. I wish they had that on camera. If anybody has that on camera, I'd be so happy. I could probably recreate it. Maybe talking. Yes, yes. Oh, she is Jenna Ellis. Where's she talking? Oh, she's talking. I'm so dumb. I'm so sorry. I apologize. Yeah, no. It probably yeah. Yeah, she's talking. That's so here. Yeah, that's so true. Oh, when I was 17, I lost my brain. I lost my brain. Mikey's crying that Fox. Well, yeah, he's done. He's done. Yes, I don't know what the Flynn drama is, actually. I don't really follow them that closely, so I'm not really sure. Gorsuck. Bathroom toe tapper. Yep. Never mind. I know. I am going to take a minute and go make myself something to eat really quickly while we've got this break. I hope you enjoy the fire, and I will be right back. Oh, oh. I didn't know anything about that pepper. Wait, what? What did I miss here? What a mess. What a mess. What a mess. What a mess. Let me see if the thing's back on because I really haven't. Oh, shit. God damn it.
We know through our
I just-
investigation, and that includes information that I have received from defense team members for President Trump in the DC case, that there has been the destruction of evidence by J6 committee, including videos of
Oh, good.
interviews and potentially deposition testimony. None of those, there are no such videos of that type that's in the DA's disclosure or production here. There is videos which I've now been pointed to that were done publicly. I'm not talking about that. I'm talking about what would be private interviews or private depositions. So I don't know whether the DA's office had access, viewed those, compared notes of investigators, but that's the thrust of where I'm coming from.
All right, let's see if we can narrow it in and focus it just to see exactly where we are. So, Ms. Young, let me start with
And it
with a
seems
few of
to,
these.
now that Mr. Sadal has kind of clarified what his request, and I'm assuming that's separate from the motion that Attorney McDougal may have filed, because it's a little bit different than what was actually posed to the state originally. So what I heard Mr. Sadal say at the end of his request is that he's asking for anything that was private, that was shared with the DA's office during this meeting that was had by Mr. Wade and Mr. Wakeford. I just want to make sure before I answer that question that that is what he's asking for, so I can answer it accurately.
Right.
May I
So,
respond?
sure, Mr. Sadao.
Yeah, and because I don't want to make this any more difficult than it may already be.
Yeah.
I am aware for certain of the 418 to 421. I know there were phone calls thereafter. I don't know whether, I don't have any evidence that other information was shared of a material nature, that is physical nature. So that's why I have focused on the mid-April activity. But yes, I also am still seeking the response, if there was one, or there is some, from the J6 committee. And I'll just, so that the court remembers, the DA's office
What do you
sent
want?
around to council on September 27th of 2023, something that they called their open file policy, which basically is, if it wasn't privileged, it's not work product, have at it. We'll show it to you. That's where I'm coming from. So yeah.
Right. And so when you say the word response, it's not potentially, let's say, an email from the committee saying, how are things and whatever else. It's actual documentary evidence that may have been turned over. Is that fair?
It's fair to say, if you look at the exhibit to the motion to compel, exhibit number 1, that is the one that was filed on January the 8th. That's District Attorney Willis's letter to Honorable Benny Thompson, in which she asked for recordings, transcripts of witnesses, interviews, depositions, electronic and print records of communications, and records of travel. I wanted to find out if the chairman responded by saying, we will give you access to such and such. Let's make arrangements for you to see such and such. That's what I was looking for in the response. If his response back was, thank you for your letter, we'll be in touch.
Sure.
That
So I
would
think
be
there's
enough
two
to
parts.
just tell me.
I think there's two parts we got to flesh out here. So I think the first question of the state would be, is there anything actual physically
Is there
that you were
substantive
provided
request?
that has not been turned over to the defense that was given to you by this committee?
And the state's answer is no, Your Honor. The state has repeatedly said that we have turned over all exculpatory evidence that we have received to all defense counsels
Okay, stop
on
with your
multiple
stupid
occasions.
MAGA
There's
argument,
nothing that we received from Jan 6 that has
Sir.
not been turned over
Sir bitch.
to all defense attorneys. And the state will
God,
also say
I
everything
really
that we
feel
turned
sorry
over
for
are
these
all things that were
prosecutors
publicly
having
out
to
there.
deal
And
with
we
these
actually
idiots.
got it from a public website. It wasn't even actually something that was sent to us by the Jan 6 committee.
Exactly.
We downloaded it from the public site in which the Jan 6 committee had put everything out that was handled during that committee session.
All right. So that would be their answer to part 1. Part 2, then, which is a little more legally uncertain in my mind, is were you allowed in the
Mm,
room
yeah,
with
so bad.
other documents or exhibits or what could be characterized as evidence,
Doesn't
allowed
it
to look
though?
at them,
Really, just clean your camera.
watch
That's
them
all I'm
over and over,
asking.
and then leave with just
I know.
whatever's in your
Should have the
head
courtroom for that.
or your notes?
And Mr. Wade is gonna answer that question, Judge, since he was the one that was present and not I.
All right.
So Judge, I think that I could provide some insight to both of the last two portions, which would be the response letter portion of Mr. Sadow's motion, and then the evidentiary portion that the court is inquiring. Firstly, DA Willis did send over a letter to Chairman Thompson requesting certain things. The tone of Mr. Sadow's letter led us to believe that, okay, perhaps we are missing something and we didn't provide something in discovery. So the time period that elapsed was due to our elaborate search to make certain that we didn't fail to provide or turn over something that was in existence. Even as late as last evening, we reached out to Chairman Thompson to make certain that he didn't send over a response and we just missed it or didn't receive it. So the answer is no, we never received a response, a written response from Chairman Thompson. Does not exist. And the only reason for the time lapse is because we wanted to search and double search to make certain that our response was an accurate one. As it relates to travel to DC, Chairman Thompson shared with
Margaret, are you
us
talking about
during this
the military
conversation
accountability
regarding
thing?
the letter
Ivan
that
Ranklin?
his directives were that we were allowed, we being the district attorney's team, would be allowed to have a conversation with his investigative team. We were not to share any information.
Yeah.
We were not to exchange any information. We could have a conversation. If there was something that we wanted to show them, we were allowed to do it. If they wanted to show us something, we were allowed to have a look at it. But there were no photocopies of anything, and there was no sharing of tangible documents of any kind.
This is not.
Would you agree, though, that let's say if this investigator had told you
Anybody
something
who
that
calls themselves a
completely
Republican
contradicted a
and not
statement that
Democrat,
you've
you would
received from a
do
material witness
at
that you'd
this
already turned
point
over to the
in
defense,
time. I'm sorry.
you would then have to document that in some way or turn it over as part of a Brady
There has to be
obligation?
a point at which
All right. And
conventional
are there any
wisdom
concerns
takes
here
over,
from what
and
you
I
spoke
guess
to
there isn't any.
with these investigators
that's the
reaching that
point.
level?
Absolutely not, Judge. In fact, everything that was shared in that conversation was made publicly available through the Jan 6 committee when they released all of their documents. So everything that we talked about, everything that they shared was
Mel
publicly
Brooks.
released.
I'd rather have Mel Brooks.
All
on
right.
this
So,
than-
Mr. Sadow,
Oh, okay.
turning back, as I
Yeah, we can
hear
talk
the
about that.
response to part one, it's that
Still?
they never got any kind of a
I mean,
formal written response from the
that
chairman
happened
for
so
them
long
to
ago, I
disclose
just
to
don't know
you.
why.
But on part two, yes, they did have a meeting and they
Maybe
spoke
it
to
didn't happen long
investigators and
ago.
they
Maybe they just stopped.
maybe shared notes in the metaphorical
Okay,
sense,
John.
but they don't have anything physical in
Okay,
addition
Red
to what's
Dawn.
already been turned over to you. What, any reactions
For
to that?
sure. Yeah.
Well, I take them at their word that there was no response. It would have been fine. Might have made this whole proceeding a bit easier if they had simply said in response to the
Oh
several
my
times that I had
God.
asked, we're looking for it, we'll let you know, as opposed to no response at all, or
Oh,
we're not
come
going
on.
to respond to you at all. But the other part of this is,
I'm
it
trying to delay
appears
you,
that there was
Honor.
a extended communication conference in which information was shared. Now,
Oh, I'm sure she
Mr. Wade
does.
has not
I'm
indicated
sure she does.
whether or not they actually gave him
Look at
documents
the
or materials that they could
Tintin,
review
dating
as opposed to
Tintin.
just communications or conversations.
Which
So
is
I'd like to know
creepy.
that. And to the extent that Your Honor has already
creepy.
hit on it as to whether or not there may be exculpatory evidence or otherwise potentially inconsistent Giglio type evidence.
He's mean.
All
My
right.
question would be,
fantasy
were there
footage
notes
that
taken
all the
by
chuds
their
will
investigators, the
exonerate
DA's
them?
office investigators,
That's what he
and
means.
or by the attorneys
Say what you
that are
mean,
still in
sir.
existence that could be supplied to the court for
What
an
did Cassidy
in-camera
do?
examination
What the fuck
to
did
determine whether or
Cassidy do?
not there is
I mean,
anything
blame her for
that the
being a
court would deem to
Republican.
be
Sure.
potentially disclosable under either its inherent power, which I've mentioned, or under due process considerations, exculpatory evidence, Brady Giglio. So that's my follow-up.
All right, a lot to unpack there, but I'll just turn it back over to Mr. Wade at face
I'm gonna say
value.
this again.
Again, Judge,
I'm not.
everything that was shared was released publicly through the Jan 6 committee. We don't have anything that they hadn't released publicly. There were no notes taken that
Yeah,
we
besides tell the truth, right?
would need to turn over or that has something in it other than what was publicly released. Our investigator hadn't.
Just to be clear, you're not claiming you didn't take notes, as I would think most lawyers would, but the idea is that you have notes and you believe those are work product.
Yes.
And you've reviewed those notes, and as of now, as the evidence stands, you don't see anything rising to the level of Brady material.
Nothing at all.
All right.
If I may, that's the first point that Mr. Sadow made in regards to the state answering yes or no to his question. The state still stands firm on the state's not required to answer yes or no in regards to whether or not they received a letter from Mr. Thompson. What
You're
the
not
state is
required to, but doesn't make the issue go away, right?
no, Judge, but the state is fully aware that we did receive information and documents that we should turn them over, and we have turned over what is public out there. So I just want to I want the court to be clear that the state was not just not answering a question for Mr. Sadow. The way that it was posed is though they were looking for communication, attorney work product, which they're not entitled to. And that is why the state did not respond as Mr. Sadow wanted the state to respond.
Confrontational? No.
We responded that yes, you have all evidence that you're entitled to through the discovery statute, through Brady, and any exculpatory evidence that may be in the state's possession. All of those things have been turned over.
All right. And Mr. Sadow, I think I
don't know.
I take your point. I understand where we are. I don't think we need to dwell on this too extensively because unless it starts flaring up again and again.
Terrible. Well, sleepy.
No, and I understand that, Your Honor, and I appreciate that these kind of disputes, so to speak, do not need the court to waste its time dealing with. That's something that counsel should be able to handle.
Okay, well,
if I may ask one other question,
there is no more information. Bye. Okay, next.
The investigators from the DA's office or the attorneys, when they were in conference, or when they were with the J6 committee, or members of the committee or their staff, were they permitted to view any videos that have not been made public?
The answer is no, Judge.
All right. All right, Mr. Sadow, if you ever receive any other indication that that is not the case, you can renew your motion and take it up at that time. However, at this point, based on what's been alleged in the original motion, it seems like that is
go to John Solomon over at just
videos presented to the grand jury, and as to the supplemental part, it seems like those concerns have been addressed with the caveat of
partner
could have been done in an email, perhaps, but we'll see.
Make up
all right. So anything else, Mr. Sadow, then?
Yes, Your Honor.
John Solomon will help you out with your complaint.
Via email that all the lawyers were told via email that you would briefly discuss the notion of adopting.
I don't know what her
co-defense
is. I mean, I think
co-defendant's motions specifically. I had asked in reference to the motion to dismiss and disqualify filed by defendant Roman's counsel on January 8th, 2024.
She's thinking the view.
Send an email along asking for leave to adopt at a later time. Does the court want to take that up now, or do you want to take that up at the end?
No, I think we can address that now. So I'm remembering that just kind of addressing the adopted motions because they've gone every which way here to try and impose some sense of order on this is that
it's true.
The conclusion had been you can adopt a motion, but that doesn't necessarily entitle you to argument on it. But then I recognize when you have a drop dead motions deadline, you don't necessarily have time to adopt your co-defendants because they just got filed simultaneously. So in essence, are you asking just to adopt it on its face, or are you looking to supplement it and go much further than where it already is?
Well,
or
actually,
essentially to join counsel at the table.
Well, actually, neither one at this point. This is the first motion in which there have been allegations of fact made, which deal directly with our opposition counsel.
What?
suffice it to say that they are salacious and scandalous in nature.
Whoa, whoa,
And
whoa.
I don't have
What are
a
they?
factual background that I can state to the court
Whose lawyer is this?
supports
I wish
that
they could
at
put
this
their name
point.
of whose lawyer am
I'm
I?
leery of moving to adopt motions that make such allegations without having a better understanding or substantiation of the allegations. What I'm trying to do here, it's one thing to adopt
the
a
client.
motion that brings up a matter of law. This is different. I was hoping the court would give me the opportunity when the DA's office responds to that motion to see what the factual disputes are, what the allegations, whether they are disputed otherwise or whether they are supported, to give me the opportunity within a few days of that response by the DA's office to make the determination whether I wish to adopt. That's specifically what I was hoping to accomplish with regard to that specific motion. Otherwise, I should be able to adopt motions right away like I did. There were certain things that were filed on January the 8th by co-defendant counsel, and I immediately adopted those on January the 9th. But this is different. That's why I put it to the court as I have.
All
I
right.
don't get it.
So
Can anybody
obviously
interpret
my
that for me?
plan with this was
Is
to allow the state an
he-
opportunity to respond
Isn't
before setting a hearing date.
whose
And
lawyer is
as for the
this,
date of a
Dempsey?
hearing,
Whose lawyer is that?
we have to work around the other trial calendars in this docket. So I think early February would be the soonest that would happen. And so I think that would give you some time, Mr. Sadow, to
Mr. Sadow.
consider any adoption if you need to. And again, I'm not opposed to just merely adopting it to preserve the issues if that's something you do want to join. So to that end, I would say you do have some leeway there, but at the moment when we've got a response from both sides and we're ready to set it for a hearing, what I'm trying to
that's Donald
avoid
Trump's
is
lawyer.
dragging it out because other parties want
That's
to
Donald
piggyback
Trump's
and do
lawyer.
their own separate investigation, if you will. There's a motions deadline and we're trying to stick to it. Am I making sense?
I understand that, Your Honor.
All right.
Yes, totally. All I'd ask for then is if you'll give me 2 days to adopt after the response. I need no additional time after that.
That is
All right.
Mr.
May I
Trump's
just
lawyer.
briefly address that?
Sure. And
Greg Gillen.
Mr. Gillen, for the record.
Oh, easily.
Our motions
My
are due
son got
February
all
the
clear
5th.
to work, brain back
Now,
in
we
place
are
and
looking
still
at that
working.
motion which has been
Easily, that
filed.
makes my heart.
We're going to do our
lift.
own
Oh my gosh, I'm so happy
investigation
for
and
you your
determine whether or not
family.
we're going to adopt that motion or supplement that motion. What our
Love your
timetable
update.
is.
I'm so
All right.
happy for you.
Understood. Thank you.
Sending you a
Does the
big
state want
hug.
to add anything?
Yay, indeed. Yay, indeed. That's
All right.
wonderful.
Anything else, Mr. Sadow?
No, I take it the court will give me at least a couple of days after the response. I'll get it in immediately.
All right. Yeah, like I mentioned, I don't know when the state is planning to file a response, but
Great news.
at some point we will have to set it for a hearing. And right now,
Great.
again, like I said, just based on the schedule, we're targeting early to mid-February. So I would imagine if there's going to be a response, it would be before that time.
Oh no, please don't.
All right. If that is all, Mr. Sadow,
It's like
I think we're going to turn to Mr.
PTSD.
Giuliani, and unless you're free to stay on if you want to.
Thank you, Your Honor.
Okay.
Weird.
So
World's a
we could have
weird
counsel
place.
for the record, your first appearance for the record here.
Alan Stockton for Mayor Giuliani, and John Esposito and David Lewis, I think, are attending virtually, and I think the mayor may be watching on YouTube.
Okay. All right.
Well, who cares?
Well, welcome, Mr. Stockton.
No,
I
I'm curious
saw
about what's gonna be
two
out tonight.
motions
About tonight, I mean.
pending that we could take up today and address. I wonder if we could start. One of them seemed a bit more straightforward than the other. So your motion asks for interviews with the co-defendants who have already pleaded guilty. As I understood it, there was nothing prohibiting that, especially from counsel. If you need clarification on that, we can give it. But your motion goes a step further and says you want to compel interviews. And I think we've got some clear case law in Georgia that says I can't do that.
Judge, I think we can take this out of your hands for the time being.
I'm welcome to hear
We've
that.
been talking with the state. And on this issue anyway, we've agreed that the issue of whether or not they could be compelled will be reserved. I think there is some law that
The mayor of
would,
Clownville.
if the court saw it our way, that you could justify compelling them to discuss the case with us. But what the state and Mayor Giuliani's team have agreed to is that we would just put that issue, just put a pin in that and wait. We believe that we'll probably be able to talk with these people. The only issue we're dealing with,
I guess he can't plea.
yes. The only issue we really have is the state is wanting to either be present or have recorded any interaction we have with these co-defendants that have already pled.
Yes.
Judge,
Have
my
you met
understanding,
your
there's
client?
case Shields versus
Have
State.
you met your client?
Closest thing
Because I have.
I found, and
I've
basically
actually
what,
met him.
that's 264 Georgia
He's a
Appeals
freaking idiot.
232.
And he lies all
And
the
basically
time.
what that just kind of provides in the periphery is that
It's
if
ridiculous.
we were wanting to speak to one of these co-defendants and they would refuse to speak to us without the state being present, that's that defendant's or that witness's prerogative. But otherwise, we would submit it. It wouldn't be proper for the state to be part of our investigation, just like we weren't part of theirs. We weren't there when the
Not
proffer
sure.
videos were
What's
made.
my
We
legal
didn't get to be a
eagles
part of
say?
that. But
What's the
that's the
legal
only
eagles in
issue
the
I believe
chat
we've got
say?
on this is whether or not the state is entitled to be present and or record or have a recording of that.
Well, I think we end up coming full circle then. I don't know if we can kind of neatly avoid the main issue, which is my understanding from the stretching back from the Georgia Supreme Court was the state can't deny you access to a witness, and they shouldn't be instructing their witnesses not to talk to you, but that the ultimate decision rests with the witness themselves. So if they and that the witness can set any conditions or preconditions that they want. So if
Not yet.
any of these
but
folks want the state to be
getting
there,
close. Getting close to the
And
dumpster
that's not our
dive.
issue.
I think they have to be.
Yeah, no, that's not our
Whatever
issue. Our
they're
issue is
doing.
the state is
And
saying
that
they
is
want to be
not
there.
Sure.
anybody's
And
fault.
we don't want the
but
state to
his.
be there unless the witness requires it.
Sure.
You're a big boy
That's my understanding
now.
of how it works and the state of the law, but I'm willing to
You
hear
must
if
fail.
otherwise.
That's all I have from our position on
Okay.
it.
Let's see where we are.
Rudy, he failed.
Yeah. I was running for the state. Very briefly, we do insist on that condition of either the state being there or having these videos recorded. Mainly for we have probation conditions, we have bond conditions, and they're there for a reason. There's to make sure that there's no harassment, no influencing the witnesses, no intimidation going on. And these are measures that would be able to remedy and be protective of those purposes and still be
he's watching
in line in conformity with those probation conditions and why they were imposed.
He's watching
as to the video recording, I think there's a second purpose in that, and that there's efficiency purpose. Once they're recorded, we've got 15 defendants. We don't want to have to subject these witnesses over and over again to interviews, and especially have to repeat themselves over and over again to each to each defendant. So I think a video recording helps alleviate those concerns, and also to help alleviate our concerns that there being any undue influence or intimidation, because they know that it'll be video recorded and be turned over to the state.
That sounds like a good compromise.
I think it's what you're proposing may be the most efficient thing, and it's certainly not completely unreasonable, but I'm wondering if this is just a kind of the necessary baggage of having a multi-co-defendant case. Based on the nature of the questions the defense counsel might ask a witness, they could consider that as revealing their strategy or where their focus is going to be.
So and saying he's the weight.
Saying that one interview is going to be able to satisfy every single other co-counsels may be a bit too optimistic as well. Everyone might need to be going down a different
here at Lolo's
road. So
what? What does that mean, Your Honor?
I mean, I can see the point. I don't think that's going to be one that we're going to be able to satisfy there.
Also,
But-
don't think we need an order yet because there's been no discovery violation at this point. We've turned over the proffer recordings, we made available these witnesses, we've given their contact information, and there's been, as to these probation conditions, there's been no threats that we revoke probation.
Sure.
Excuse me.
Right. And to the state's other point of, well, we have these conditions of probation and we need to make sure they're not violating them. That's a fair point, but there has to be some kind of limiting principle. The state didn't ask as a condition of probation that they're monitoring all conversations of any of these defendants who have pleaded. And I suppose there's a heightened risk, if you will, when you're dealing with a co-counsel, but I think there always has to be some level of professionalism and trust involved when we're dealing with officers of the court. So let me ask Mr. Stockton, is this something Mr.
you met
Giuliani
these
was
lawyers,
planning
sir?
to be sitting right there in the room as you interviewed these people?
No, not at all, Judge. He unless there is an apartment in New York, he's not coming down here to interview or where these people reside at the time.
Clip it.
Judge, and I don't think I've completely hit on this, but the main reason I filed this is in the colloquy, and when you were announcing your sentence, one of the things you said was,
I like his
and
tie.
this was just
I
on
like the suit.
defendant Jenna Ellis. She's not to have any contact either personally or through other
That's true.
agents.
That, they did say that.
I don't think this is what the court meant, but at the same time, I can see somebody that's wanting to comply with the letter of this that might need some clarification from this court that it is okay for them to
I think he just
discuss
said that, didn't he?
this with not the defendants themselves, but with the defendants' representatives.
All right.
Mhm.
Well, just again, anticipating that this may be a concern with other co-defendants as well, I think it's worth, I'll file a brief kind of order and response. Again, I think I need to reiterate that
Smelly cat.
the black letter law here is that a witness can't be compelled to speak
Ew,
with
yuck.
defense counsel. If you want to raise that by later down the road, if we know they are,
And
and you
then
think you have case
will-
law
will-
in the alternative, we can take a look at that. But
will-
essentially, a witness can't be compelled to have an interview. The witness gets to set the conditions. If they want the state there, I think the state gets to be there. If they don't want the state there, I think they get to speak with you privately, and they're pretty much the ones in control at that point. There weren't any other conditions as part of their sentencing that proved otherwise. Right. All right. Is there anything else then we think we should clarify there or needs to be addressed?
No, Your Honor.
So then we move on to Mr. Giuliani's more substantive motion.
Here we go.
Respectfully, Judge, I think we can handle this even quicker.
Okay.
Oh, really? Did you
I
withdraw it?
remain cautiously optimistic.
Judge, this was filed by Mayor Giuliani's prior counsel on
Yeah.
September the 8th
Oh.
of 23. Shortly thereafter, they withdrew from the case. The court set down motions hearings on pretty much everything except this one.
Wow.
So the state hadn't
Wow.
responded
That's
at that
true,
point.
huh? Wow.
I filed a motion for a hearing on this, and very quickly the court set down this date, and the state has not had an opportunity to respond yet. In
No,
talking with
no, we
the
can resolve it
prosecution,
now.
Judge, what we've discussed, if it pleases the court, to begin with, a lot of this has already been taken care of in argument. You'd just be hearing redundancy. But there are three areas that I don't believe have been addressed, and all three of those areas deal with the overt acts that occurred in other states.
Sure.
And one of them had to do with equal protection. One of them had to do with Brady issues, and the other had to do with jurisdiction. In talking with the state, they were going to, if it pleases the court, no argument today, them present their side of it in writing to the court, and then maybe give me, if I need to respond, another 10 days or so to take care
Oh,
of
come
that.
on. Let's stop this.
All right. And then we just handle it through the briefing.
Yes, Judge.
All right. And just by way of kind of focusing in the briefing, Mr. Stockton, on the equal protection issue, just when I was kind of making a preliminary look through it, I want to make sure I understand the argument. It's that, is the concern simply other states could prosecute your client for the same predicate act?
Yes, Judge. And for instance,
Well, then I guess he shouldn't
arguably
have broken the
Georgia,
law in so many
you
states.
can't be sentenced for the RICO and the predicate act.
I mean,
But in Florida, you can. There's just
Sure. So,
Georgia.
but how does that become a double jeopardy issue if
Right.
all the states are separate sovereigns?
Exactly.
I mean, couldn't he be convicted in
He
every
broke
single
the
state,
law in
all 50
several
states,
sir. I
if
guess
there was
he
an
couldn't have
issue
done that.
without any double jeopardy concerns whatsoever?
I don't know. Those are separate
You may have a
acts.
point, Judge. I mean, there may be something to that, but
They're separate acts, honey bunny.
All right. Well, that's something to focus on in briefing.
Well, bless your heart. They're separate
Thanks, Judge.
acts,
All right.
sir. You need to sit down with your
Okay, then.
ivory tower.
We'll take that up on the papers.
That was
I
embarrassing.
guess since we
I am
are all
not a
here together
lawyer.
still, I can open it up to general housekeeping
even
for
I know
everyone
that.
who's still here and with us.
Certainly, Your Honor. Catherine
Okay.
Bernard here for
Even
Jeffrey
I know
Clark.
that. Even
And
I
we
know
had
that,
adopted
even I know
President Trump's motion to compel, and it looks
that.
like the court has ruled on those issues at this point that the representations of the district attorney's office that they have not been given access to any classified or private information that is not publicly available, but that the court is willing to revisit that ruling should any additional information
Oh,
become
shut up.
available.
Sure.
No.
We understand that correctly. And we did also, there has been quite a bit
Yeah.
of communication
very
back
good,
and forth
Judge.
via email between the district attorney's office. And so out of an abundance of caution, the district attorney's office had included some of our previous requests specifically
Tom, I
for
have to do
communication
that.
based on
Tom,
TUI
thank
regulations
you. I'm so
and whether or
sorry.
not
I'm
TUI
checking
letters
my
had been
email
received for
recently, so I gotta
Mr.
get
Rosen
back
and
on
Mr.
it.
Donahue. And so we did, out of an abundance of caution, flesh that out into a new motion to compel, simply filed on behalf of Mr. Clark. And we are prepared to take that up today. And
Jeffrey
I do have
Clark's
copies for
lawyer.
the state. But of course, if the court would prefer to hear that at a separate time.
No, I
we
want to
are
hear it
available.
now.
Right. So I think you filed that today. I was able to read it, but obviously we didn't notice it for today. So if the state's not ready to hear it, then I think we need to give them an
Criminal
opportunity
complaint?
to digest that and
Cassidy
respond.
Hutchinson?
But perhaps we could at least make sure we understand and we're focused on the issues at hand. Well, actually, first, let me just ask the state if they want to take it up today in the spirit of efficiency.
Judge, we appreciate that, and the state, of course, it's of course willing to give us time. We will take all the time that the court's willing to give us.
So did nobody know that the state
Okay.
was coming
How much
up
time
for
do you
their
need?
pending motions? Did
Couldn't
nobody
hear whatever
decide
we
they were
said
going
for
to
the
do
next,
their
since we're
work?
talking about
I'm
moving
confused.
forward the next hearing date that the court said. I would just say maybe not next Friday. It seemed very jam-packed, but maybe the next hearing after that.
All right. And Ms. Bernard, I just want
People, we
to,
gotta
again,
move
to
this
focus the
along,
issues.
okay?
That motion,
Oh my
we're
God.
honing in on the actual communications between
actually is
council and the
important
committee
that
or the
this
White
case-
House.
These
Right. It's
cases
not so
take
much what
some
Mr. Sadow was getting
priority
at in his
to
motion to
some
compel
degree,
about
you know,
what
whatever.
other evidence, documentary or otherwise,
We've got
came
an
as a
event.
result. You're looking for the actual communications that have occurred between the two entities, right?
Yes, Your Honor, particularly if there is anything in response to the request for a TUI letter that we believe was made for both Mr. Rosen and Mr. Donahue. It has been reported. We included as an exhibit to our filing some of the media reporting that indicated that that request had been rejected. And we do believe that that would be material and relevant to Mr. Clark's defense.
What?
As a defense of
Of what?
And Your Honor, at this point,
I don't want to express it.
we believe that
You
it would
don't
be
have it.
material and relevant, particularly if Mr. Rosen and Mr. Donahue, who are the main witnesses, who we believe they are prepared to provide evidence against Mr. Clark. That is
Yeah.
the case with his ongoing proceedings within the District of Columbia.
Uh-huh.
And so we believe that if they are not going to be available as witnesses, that will be tremendous. That will be a tremendously important element of the case going forward.
What?
right. So if an investigator is out there trying to put a subpoena in a witness's hands and they just can't find them, is that something that you also think falls under Brady?
Potentially, yes. I don't know that that would be the analogous situation here, since it does involve intragovernmental communications, particularly with the individuals who potentially are responsible for initially leaking the draft letter that was in late January of 2021. So again, we're looking for the information. We're looking for at least a response from the district attorney's office as to whether or not they received anything back from the Department of Justice in response to that request.
Right. So I'll just give you my initial reaction as a preview to, as the state gets its response in the hearing, is that I think the first aspect of it seemed you were raising concerns or kind of building an argument about selective prosecution, right? And that has more of a legal hook, if you will. But the latter half of it was talking more about,
was stupid.
Just to boil it down, hey, we need a heads up of who could actually be able to walk through the courtroom and present evidence. That was a kind of a more novel theory to me. So if you've got something else that kind of connects those dots, I'd be welcome to hear it. But that by itself seemed like a bit of a stretch. So we'll take it up at the hearing and
Twitter.
open the floor back up. I don't know who is still
You know what? The only thing about
with us at
Twitter
this
is
point, or
it
if there's anything else to
integrates.
address, or if it's kind of petered out, or where we are. But anything else?
My experience.
Okay, then we will stand adjourned, and we'll see you
Well, there you go.
next Friday.
There you go.
Thank you,
We're
Your Honor.
gonna
Thank
you,
be
Your Honor.
back here next Friday. We're gonna be back here next Friday. Hey kids, how you doing today? How you doing? How you doing? How you doing? Yeah, so I guess we're gonna be here next Friday, which is fantastic. Sounds great. Actually, I think it's like I feel like I'm starting actually a new season of Lolo's Lounge, and maybe what I might do is try to move it to Saturday nights instead of Friday nights. And maybe, yeah, I think I might. Given that the court schedule is going to become more and more packed. I think it would probably be smart to go ahead and see if I should probably do that. I should probably do that. I think I will do that. And so I won't see you tonight. But you never know. I might be on Twitter on Spaces. Sometimes that comes up at the last minute, and then tomorrow night, oh my God, and especially all the folks who are new, welcome. If you come tomorrow night at 6:15 Pacific time, 9:15 Eastern PM, and everything in between and outside of that and all over the world, then you will come into Lolo's Campfire. Let me show you. I'm going to show you the logo. Hold on. I'm going to wait. Let me open the logo. Oh, actually, I can show you the background. I'm so silly. Oh, silly girl. You're so silly. Okay. This is I'm going to take myself off screen for a minute, but this is going to be the background, and this is the logo for Stories by the Campfire, which is something I've dreamed of doing for very many years. So that will be really fun, but I'm going to take myself off for a minute so you can see the whole logo. Oh yeah, that's what I called it. Around the Campfire with Lolo. It's been a minute, okay? Okay, it's been a minute. Anyway, so hubby has allergy to pine. Terrible. I have an idea easily. Can you DM me on Twitter if you're on Twitter? I don't know if you're on Twitter or not, but ciao bella. Ciao bella. Ciao bella. Bellissima. Ciao bellissima. Te adoro. Yes, aren't they cute? And so if you come tomorrow night, isn't it awesome? Then we can tell ghost stories, and we can sit around and snuggle and have like a snuggly Saturday. So please, please, please come back for that. And then obviously there will be more. There's a lot more on my YouTube page. If you go to Lolo's Lounge YouTube page at Real Lolo, on YouTube, you can see the upcoming live streams. We've got a lot, and every time I hear about another court appearance, I'll be placing more of those things in there. Also, if you're new to the channel, we also read a lot of the documents that come out because we believe in original sources and media literacy. That is a primary theme here at Lolo's Lounge. We want to know from the source of how we're going to do that. Oh my God, please easily, like, even if you want to just email me, if someone doesn't want to talk on screen, but you want me to read your ghost story, like anonymously or whatever, email me. My email is on my about page on my Real Lolo. Sorry, I keep like almost, whatever. I'm doing some things to my microphone and I need to stop. Okay, the point is on my about page on my YouTube, Real Lolo's Lounge. My email is on there. So please send me an email with your ghost story if you don't want to come on to voice or anything, or you want to be anonymous or whatever. And let me know that you want to be anonymous, and I will not say who sent me the story. So but yeah, I would love that. Oh my gosh, the more the merrier. The more the merrier. I'm going to curate a whole bunch just so that we have stuff to fill time. But I'm trying to plan a bunch of fun little surprises too in the middle of it. So yeah, it'll be fun. It'll be fun. It'll be fun. I know, it's Democracy Dino is another character that I have. I actually do dress up in an inflatable dinosaur costume, and the recent protests that Democracy Dino kind of was at have been protesting Dinesh D'Souza's movie Police State, and at its special showings here in the Los Angeles area, and then over in Burbank. I went to one in Burbank and one in Los Angeles in Beverly Hills. And then also I made a few appearances at the writer's strike at Paramount Studios here in Hollywood. So Democracy Dino also has her own channel, and she is all about media literacy and voting rights and rights for everyone. So make sure you give her a follow too, because she's the backup channel right now. So, but Democracy Dino's fun, and we have lots of fun with that whole concept. So anyway, have an absolute wonderful Friday. I hope you have a really awesome fucking Friday night, and I hope like you have a date or something. I don't know. I hope you have whatever activity you want to have when it comes to your Friday. So I'm going to probably watch like a couple of horror movies, because that's what I do. That's what I do. I'm boring. What can I say? Anyway, thank you. Oh, he will not be named. Well, you're so welcome, sir. Thank you. And I really appreciate everyone coming. I cannot imagine. I know you've got other ways to spend your time. So I'm really grateful that you come and hang out with us here at Lolo's Lounge. I have the best chat friends on the internet. They come and they share, and I really adore them. So thank you everyone for coming. Okay, enough of that smarmy crap. Let's get out of here. Go home. I adore you, but you can't stay here. Go. No, you go. You hang up. No, you hang up. Okay.